I have filed an executive reply on 7th. May it fall for
The concern of the business council, I went to my son, I was 20, yes, PS Loper is repairing his subject from the video. I will. Okay. 2 weeks.
Who's for the respondent?
Yeah, I am for the respondent.
You are for the, who's for the petitioner?
R. Mazumdar, second concern.
Item 20.
20, yes.
20. At the request of Mr. K.K. Korakor, making the request on behalf of Mr.
PS Loper.
P.S. Locker. Matter still in the jail. For 2 weeks. 2 weeks. It is submitted, consent of the petitioner has also been obtained.
How is it?
Hello, my document for listing of a litigation in admission.
Which year?
I got 2023. This year,
23. When was it last listed?
2/6/2023.
It will come on 28 September, August, 28 August.
Wait, please, Lordship. Lordship, with this concern from the other side, I'm from respondent. We have just received the Federalist comment that I take some time to.
Which matter?
Item number 31.
31. 31, these pairwise comments, you make a mention when the matter is called up.
Yes, sir.
Now, who's for the petitioner?
Yes, sir.
No objections.
No.
Item 31 at the request of Mr. D. Bora. Adjourned for 2 weeks, enabling him to complete his instructions. Mr. M. Das, the counsel for the petitioner, does not object.
With the consent of the other side, I would take, I would like to mention item number 23.
23.
Your Lordship, I have received a copy of the affidavit filed yesterday by the respondent, number 5, later in the evening yesterday.
Mr.
Teacher.
P. Chaudhary, learned counsel for the petitioner, prays for and is granted 2 weeks time to file reply affidavit in the matter. He submits the counsel for the other side. Consent.
You know this.
You know, Mr. K. Gogoi, learned CGC does not object to the prayer, at least after 2 weeks.
Item number 26, madam. Okay, I take a concern of the other side. 1 week time to file my affidavit, madam.
26.
26, madam.
1 week time, 1 week time. Okay, you have taken consent.
I have taken concern of the other side. It may be fixed, madam.
MS, MN Kotoki, learned standing counsel. Animal husbandry submits, prays for 2 weeks time. 1 week.
1 week time, madam.
1 week's time to file what reply. What do you want to file?
Affidavit, madam.
Affidavit in opposition. It is submitted, consent for the petitioner has also been taken. Matter be listed after 1 week.
Oh, less.
May it be the, I get to mention for listing of the matter
What matter?
for admission.
Admission 28 August. One 8, 18 and 19.
For 1 week.
Why?
Regulation matter, we are updating the district judgment for the 648 hearing.
Item 18, 19 at the request of Mr. P.P. Bora, let us stay in the jail for 1 week.
Supplemental is for withdrawal, item 52.
May I please your worship, my lord, the order dated 15/6/2023, my lord, that has been complied with, my lord. There was a direction to convene the DPC meeting, my lord.
You are for the petitioner.
Yes, my lord, I am for the petition.
Mr. D.P. Bora, learned counsel for the petitioner, submits that the directions contained in the order dated 16/6/2023, passed in 3/445 of 2023, has been complied with by the respondents. Stop. The direction was to consider the case of eligible candidates, including the petitioner for promotion to the next higher rank of additional chief engineer civil, in accordance with law and in the department of
In the department, public works department.
PWD, within bracket and H words. Stop. In that view of the matter, the contempt petition stands closed. Anyone for the respondents?
No, my lord, because that's
None.
looking for the issue, my lord.
None has appeared for the respondents. Notices issued on 26/7/2023 and stand recalled.
Acknowledgement.
Daily list item number 1.
Yes. Where is Mr. H. Sharma? He was asked to get instructions as to the status of the survey. Yes, madam.
Respondent where did they start?
Yes. Where is Mr. H. Sharma?
Just call him.
Calling him creates a problem. We have to defer it for the time being.
Lordship, may I read out a note from his, he has given a telephonic instruction he has been given. Both the petitioner and the private respondent are now working as assistant deputy controller senior in civil defense, which is equivalent to inspector. But this is only what he has written in the air, otherwise we have to call him.
Petitioner working as inspector. Sorry.
Working as assistant deputy controller within the SR, your lordship.
I don't think that's the company.
You are a civil defense demonstrator,
This one should.
and the other gentleman is PBX operator. So now what are they working as? Civil defense,
Assistant deputy controller,
assistant deputy controller,
both.
assistant deputy controller. Which is equivalent to,
So which is equivalent to inspector, your lordship. That is what is written in the.
what is the status of the petitioner today? No, I'm asking you, your client, what post is he holding today?
Not, civil defense, demonstrator.
That was at the time when the petition was filed, today.
Right now, we don't have instructions.
Then we close it, he's been promoted.
Check, if they pass through the family.
What will happen if I pass over? Your senior will come, all right, take it up.
But I will also call Mr. Sharma.
Yes, please.
Item number 2.
To Manu, I will matter. Yes.
Petitioner is concerned about NCRPF in lordship. On the basis of a complaint filed by the wife of the petitioner, Miller, the respondent authority has initiated departmental inquiry in lordship. It's an allegation that the petitioner has recognized plural marriage without obtaining the divorce from the first person.
All right, we'll issue notice.
Willard. In this case, Willard, the petitioner and his wife, certainly a dispute, Willard. I have annexed the document. Willard.
So you approach the department and tell them there is no dispute.
I have submitted for the document here, okay.
Hmm.
Thereafter, one letter has been issued. That states 7 years. Now, annexed 7 page 40 years.
What is that letter?
Page 40.
So we're appointed as an amicus curiae. Sorry, inquiry officer.
Right.
What is that 41, 42?
42 subsequently issued this letter. Stating the preliminary hearing of.
What are the charges? Have you received the charges?
My lord.
Where are they?
Page 25, article of charges development. Yes, case 25. I think there is that on the complaint, what were the words? For the timing, my lord, the departmental inquiry may continue state, my lord. And the one.
Come to page number 26. There's some inquiry report is already against you, perhaps a preliminary inquiry.
My lord, this is from police station.
No, inquiry report dated so and so received through Commandant so and so.
Through commandant, my lord, but
Where is that report?
that report I could not obtain it.
So let them get the report.
Some police case was also filing.
But apparently, the charges are for conducting plural marriage.
Yes.
And rule 15 of the CRPF rule provides that no member of the force who has wife living shall conduct any marriage without first obtaining the permission of the government, notwithstanding that such subsequent marriage is permissible under the person of the time in force. So, my lord, the allegations are that he has conducted plural marriage without permission. Now he is seeking stay of the departmental proceeding on the ground that my lord, a divorce proceeding has been filed subsequently,
Maybe.
which cannot be malad, so that my humble submission, there can be no stay of the departmental proceeding. It is
No, but
right.
what are you inquiring about?
The plural marriage.
So, on
whether-
what are you having, what are your documents or materials? Before the, how will you establish that plural marriage has been conducted? Do you have any materials?
It is there, the statement that is subject matter of a disciplinary proceeding,
That's right.
that will be proved, but the conduct of the disciplinary proceeding, cannot be stopped because they are seeking stay merely on the
Conduct
ground
of the disciplinary proceedings can be stopped if it is found to be needless. Unless you have materials to say that.
you can very well contest the departmental proceedings. Allegations of plural marriage are there, will take the charge.
You come to page number 26, you get the report at serial number 1. You have a copy of the report with you.
No, right, I will have to get this.
That's what we want you to do, get the report. Heard learned counsel for the parties issue notice, returnable 4 weeks. Since Mr. So-and-so appears for the respondents. Notices are waived, you appear for all respondents,
No, private respondent is also there.
appears for the respondents 1 to 5, notices are waived. Have extra copies be furnished within a period of 1 week from the date. During the course of the week, steps on private respondent by registered post AD. Learned CGC will file necessary affidavit if so advised. Responding to the contentions made in the petition. This after 4 weeks. Prayer for interim after completion of service.
The first petition has been filed jointly, but that cannot be
Before whom?
because the principal that's the.
Any order passed?
That is pending.
Then
It's filed subsequently, my lord.
the very fact that you have filed a petition. Seeking a divorce, I do not know what grounds are there. It may reveal that you conducted a second marriage.
It was filed by the petition and his wife jointly.
Some criminal petition is also there.
The
Plural marriage is there,
the timing, maybe same.
No, it can't be stitched. We are not rejecting your interim prayer, we consider upon service of notice.
Must have been.
Prayer for interim to be considered after service of notice.
Item 3,
A return of service.
The issue pertains to withdrawal of voluntary retirement application. Annexure 7, the petitioner, my lord, on 30th April 2022, page 29, Annexure 7, he has submitted the application for voluntary retirement after serving more than 37 years.
Page number
Page 29, my lord.
29.
Due to some domestic problem, my lord, he has submitted the application.
Hmm.
But then thereafter he took leave and the matter was sorted out. And Annexure 9, my lord, would come at case 31. He sought to withdraw the application for voluntary retirement. At Annexure 9, on 13th May 2022, that is 1 month after the application. The law is well settled, doctor knows that at any time before acceptance, application for voluntary retirement can be withdrawn. There are a number of decisions to that extent. Thereafter, my lord, everything was going fine till my lord, May 2023, all of a sudden, my lord, my retirement order comes out. Saying that I am retiring. Page 37, my lord, is impugn communication and except where. It says that, my lord, the retirement is due on 1st September 2023, my lord.
No, is this retirement on superannuation or
No,
then in terms of this voluntary retirement? How many years of service do you have?
3 years, 3 months. It's 56 as of now. So the explanation is 67. Sorry, man, it's 60. It's 60. Communication says that it has been accepted on 10/10/22. They have made a reference.
Where is it?
That communication of my lord.
Authority letter,
Case 37, and it's a 12.
authority letter.
Authority letter, my lord. So that means the acceptance of the VLS. They've ignored the fact that I had withdrawn my lord, my application already. And this communication has come.
This withdrawal, when was it received by the authorities?
The withdrawal, my lord, was submitted and received on the same day. Page 34. The concerned, Madam Subedar of the unit, he has received the application. Page 34. Basically, one the instruction went out that happened to my application for withdrawal. Once that is submitted before my actual order of retirement. We have also have acted my law.
Who's for the respondents?
Central Government Council member.
Your counterpart is not here. Somebody was here while ago.
Normally private the office will have. Or I was like thereafter.
You inform somebody.
I will
Inform somebody.
I'll try to. We have some time till work out. September is my out day.
Yes.
Instructions come before that, I don't probably the matter.
Therefore, the presence of the
My-
council
my-
is software. If the council is available, you inform the board master, matter will be reported.
Smile, give you.
Item number 4.
Yes.
This was right in the year 2013. I can find the application or the putting time and British Lordship, the 29/7. His application is neither rejected nor been recommended by the AHC. That is taken.
Yes, Mr. Bora. Our learned counsel from the party, this petitioner has approached this court. Being aggrieved by the fact that his application seeking compassionate appointment, which was submitted on 29/7/2013, and which was forwarded to the additional deputy commissioner Hemaji on 6/1/2014 has remained unattended. Stop. in spite of his in spite of approaching the competent authorities and seeking information regarding the status, the petitioner has not been informed about the status of his applications. So, having no alternative, he has approached this court by filing this writ petition. There are Mr. Bora, learned counsel for the state, subjects that instructions will be necessary in the matter. Considering the fact that the petitioner has submitted the application and no information has been furnished to the petitioner, let notice be issued returnable 4 weeks. Since Mr. Bora appears for all the respondents, for the respondents, 2 and 3. And Mr. Dhar appears for 1 and 4. Notices are, oh, you're appearing, sorry, MS so and so appears for 1 and 4. Notices are waived. However, extra copies be furnished within the course of the week. Let the matter be listed after 4 weeks, enabling the respondent counsels to furnish enabling the counsels to obtain required instructions and place it before the court regarding the status of the application stated to have been filed with the petitioner. List on it has to go to September 7th.
Similar.
When are they fixed?
Similar, it is fixed on first of September.
First, list on 1st of September.
Okay, on the list.
Item number 5.
None appears for the petitioner involved. Mr. C. S. Azorika appears for respondent
6 years, only at the most.
respondent 6. And Mr. Chaudhary for respondents 1 to 5, 7 and 8.
1, 2, 3, 4, 5, 6.
7 and 8.
7, 8, 9.
Yes,
My civil is in another court. Can you pass on the matter for?
we cannot. I heard so and so, this application has been filed with the petitioner. Agreed by the fact that his application for seeking compassionate appointments pursuant to the death of his father has not been given due consideration. Stop. Where is the last order of the court?
Page 20, 21 years. It's 21 to 23. The multi-party time is 23. It's 22 last.
What has happened after this order?
But if nothing has happened,
Then, why did you not file a contempt?
but the capacity is launching.
Huh?
The capacity in the year 2015 or next level selection committee was formed. And accordingly, a communication has been made to the authority and also to see. Case 25 years.
Then,
Thereafter, case. And page 26 will not be. The deputy secretary has. Directed the district agriculture officer regarding the constitution of the district level committee
This is level selection committee for appointment of members. And in 2015, we also faced 27.
What is the meaning of 28, Mr. Chaudhary? Page 28.
We watch it.
First of all, I don't make it.
Hmm?
What they intend to say. It appears that there was lack of vacancy. Few numbers from 1997 to 2016.
Yes. 97, the additional deputy commissioner has been
This OM 16/2015 is applicable. This 29 is by whom?
Yes, 21, the director of the
29, 28.
director of the
Director is what? Is it for the DLC?
What's it, DLC. Ultimately, it is forwarded to the principal secretary who takes the decision.
Case 27 में kindly verify.
DLC is headed by a DC.
Yes, he is one of the members.
Director is one of the members.
Principal secretary, BDC is there.
Then we dispose it off in terms of clause 15. Heard counsels for the parties, this petition has been filed by the petitioner. Agreed by the fact that his application for seeking compassionate appointment has not been given due consideration. So the father of the petitioner was serving as a peon in the office of subdivisional agricultural officer Pichni. And he died, he expired on 15/12/2001 while on service, while in service. So the petitioner submitted his application for compassionate appointment on 18/1/2002. Since no action was taken on the said application, he approached his court by filing a writ petition being WPC number 6592 of 2002. Stop this court by order dated 8/8/2002. Disposed of the writ petition directing, where is that order?
Case 21.
Directing the respondents to consider the case of the petitioner for appointments on compassionate ground within a period of 3 months from the date of receipt of certified copy of the order. So the case of the petitioner was directed to be considered in terms of the claims, in terms of his claimed eligibility, and in the light of the policy in force. The consideration was directed to be made along with other similarly situated persons and subject to availability of posts against the quota earmarked for compassionate appointment. So in terms of the same direction, the matter was processed. And it is the same case which is being processed, or you file a separate application. The matter was considered at different levels, at different offices for the last several years. And ultimately, by order dated, by communication dated 17/11/2021, the petitioner's case was rejected, was not forwarded on the ground that adequate vacancies are not available. And also keeping in mind his family conditions. Now, in view of the lack of vacancies, stop. This communication was addressed by the Director of Agriculture Vacancy, Obraja, to the Chief Executive Member, Bodoland Territorial Council, Obraja, dated 17/11/2021. Stop. It is this non-consideration of the petitioner, in spite of directions issued by this court, that the petitioner has approached this court for a second time. Yeah.
Page 27, it will indicate Commissioner Kiran letter forwarded the application of the Tajikistan for consideration by principal secretary PDC.
Learned counsel for the petitioner submits that his application was duly forwarded by the additional TC, Chiran, the principal secretary BTC, for due consideration. However, in spite of that, the Director Agriculture has neglected to consider the case of the petitioner. Stop. Better. Mr. Chaudhary, any submissions?
Lordship, only one, there is a delay, Lordship.
Mr. Chaudhary, Standing Council KTC submits that there is a delay of the petitioner in approaching the scope. Therefore, the application may not be entertained. Stop. There are learned counsels for the parties have been heard, taking some report are every hearing. So it is seen that pursuant to the directions of this court, dated 8/10/2002, passing WPC 6592 of 2002. The matter was processed at various levels, and ultimately the additional Deputy Commissioner Chiran had addressed a communication to the Principal Secretary BTC in the year on 2nd of March 2005, 2015. But how do you know this is your application?
My name is Rebecca David from the automotive.
Has been considered, has been forwarded for consideration. A copy thereof has been addressed to the petitioner with endorsements made by hand, and which is relied upon by the counsel for the petitioner to submit that the case of the petitioner was indeed considered and recommended, was duly recommended by the additional Deputy Commissioner Chiran for due consideration. So the OM dated 1/6/2015 clearly lays down the procedure and in the manner in which the applications for compassionate appointment are to be considered. So at clause at para 15, it is specifically provided that in the event the vacancies are not available in the concerned department, then the administrative department will ensure we find out from other departments whether vacancies are available, and then pass adequate notice. Stop. As per the OM, The applications are required to be considered at the first level by the DLC, which is headed by the Deputy Commissioner, of the concerned district. And if recommended, the same are to be considered again by the SLC, in which the Chief Secretary of the State is the chairperson. So the communication dated 7/11/2021 issued by the Director of Agriculture, whereby the case of the petitioner was held to be not. Whereby it was communicated that the case of the petitioner cannot be considered due to non-availability of vacancies, cannot be accepted to be a recommendation of the DLC. Although the Director of Agriculture, as submitted by the London Standing Council of Agriculture, is a member of the DLC. So, in that view of the matter, considering that there is already a direction of this court by order dated so and so passed in WBC so and so, the respondents are required to comply with this order in a manner prescribed under the relevant rules / notifications. So failure to comply with orders of this court expose the respondents to contempt of this court. However, considering the fact that the petitioner has also approached this court after some amount of delay, the court does not wish to invoke. Court does not wish to pass any orders under the contempt jurisdiction. Stop. The court is of the view that interest of justice will be subserved if the petition is closed with the direction to consider direction to the respondents, more particularly to the DLC, to consider the case of the petitioner in terms of the relevant OMs / notification, and if found to be and if the petitioner's case is found to be can be considered, if the petitioner's case can be considered as per the provisions of the state OM / notification, the same shall be considered and appropriate orders be passed thereon. So this exercise by the respondents will be carried out without fail within a period of 45 days from the date of receipt of the certified copy of this order. In terms of the above, the petition stands closed.
Timing item number 3.
Yes, second marriage.
No, my lord, that's voluntary retirement.
Voluntary, sorry. Yes, withdrawal of voluntary retirement.
That is almost, order was passed in the month of May, now. It is effective from 1st of September. May I say that this matter is listed on 21st in the meantime in the request?
31st. 21st.
We normally don't get leave, my lord. Therefore, so it's present in armed forces, they have some delay in filing.
No, you get your instructions, we'll have it on 21st.
My lord. That was
Third learned counsel for the petitioner. This application, this writ petition is filed by the petitioner. Praying for setting aside, interfering and setting aside with the
Connection.
unacceptable.
Order, Battalion Routine Order, Part 2. Issued on 10th May 2023, showing that the petitioner's retirement will be with effect from 1/9/2023. Stop. The counsel for the petitioner submits that because of certain personal and family issues, the petitioner had submitted an application for voluntary retirement on 30th April 2022. Stop. However, subsequently, before the same was withdrawn on 30 May 2022 by written application. Stop. Thereafter, no communication was forthcoming to the petitioner, and he was under the impression that his application for voluntary retirement has been allowed to be withdrawn, and no further orders or communications are necessary. Stop. However, in view of the impugned battalion routine order part 2 dated 10th of May 2023, petitioner is now been informed that he will be retired from service with effect from 1st of September 2023. And the petitioner is aggrieved because of the fact that this order has been issued without considering his application for withdrawal of voluntary retirement. So the petitioner has otherwise 3 years of service left. Whereas Mr. Counsel for DSGI appearing for the respondent submits that matter be listed again on 21st, by which date he will obtain the required instructions in the matter. Accordingly, let the matter be listed on 21st, and on which date further orders, if required, will be passed. Although notices have not been issued, learned counsel to the petitioner will furnish extra copies within the course of the week to enable the DSGI to obtain required instructions. List on 21st.
Item number 6.
Yes.
Yeah, now this is regarding compassionate appointment matter. My case has been rejected by the state level committee matter, page number 29 matter, in minus matter. And relevant portion matter, page number 31 matter, due to lack of vacancy matter. Page number 31 matter, in the table matter, serial number 3 matter. Due to lack of vacancy matter, as part of 15 matter, my case may be considered.
When did you file your application?
Application
The 99, मतलब ये father died 99.
Yeah.
4 years. after that.
96.
Ah,
This is my application. Thereafter, my lord, page number 14, my lord. DLC, district level committee, page number, relevant person, page number 14.
hmm.
In the year 2010, my lord, my project has been considered by the DLC member. Page number 12, DLC member.
Page number
Page number 12, my lord.
12.
12, my lord.
Where is your name?
Relevant person, my lord, page number 14, my lord.
Hmm.
Serial number 5, my lord.
Bill number 5.
Serial number 5. In the year 2010, my lord, my name has been considered.
Recommended.
Thereafter, my lord, page number 18, my lord, the state level committee, page number 18, my lord.
In 2014.
14, my lord, state level committee has again rejected my relevant portion, page number 20, my lord.
Hmm.
20, serial number 19, my lord.
Hmm.
19, more than 2 years has been passed from the date of application. Thereafter, my lord, a petition has been filed, my lord, petitioner along with 5 other candidates, my lord, page number 25, my lord. And that, my lord, the ground has been set aside by this ombudsman court, my lord, page number 28, my lord, the legal form. Paragraph number 8, my lord. 28, paragraph number 8, my lord. The state, my lord.
Hmm.
The rejection of the application of the petitioners number 2, I am petition number 2. And 4 by the state level committee on the ground that more than 2 years.
Anyway, so it was interfered with.
No, my lord.
And the state level committee was
And
requested to
thereafter-
direct,
Yeah.
decide.
My lord, thereafter,
Now,
state level committee, my lord, again rejected, my lord,
hmm.
page number 31, due to lack of vacancy, my lord.
Bound to be 99, 2001 vacancy. How will it? Where will it be there?
My lord, I have no fault, my lord.
You may not have a fault, but there are no vacancies available.
My lord, any other department, my lord,
Huh?
any other department, my case may be considered, my lord.
That report it has come in 2019
My lord.
and you have come in 2023.
We get about
My
48
case has
years.
been rejected by 2019, my lord, state.
Correct, you are here before the court in 2023.
And these findings has been communicated in the year 2022, my lord. Last page, my lord, I have, to RBI, my lord, I have got it, my lord, 2022, my lord.
Your case was not considered
My lord.
for vacancies of 99, 2001, it is meaningless. Meaningless. Can there be vacancies available in 99, 2001? Unless you set out a claim that it is a case where vacancy is not there, your vacancies in 2019 onwards will have to be considered.
And, the 2019, my lord,
Hmm?
and 2019, I have a.
You have done everything, but you have not been very vigilant. You have an order in the court, you have an order of the court
My lord.
of 2018.
18, thereafter 19 December.
19 it was done, you waited.
And I have got it to 2022, my lord. These matters are not communicated, my lord. I have got it to RBI, my lord.
What was the direction of the court?
Direction, my lord, to consider, my lord.
Consider what?
Page number 28, my lord.
To place the address, not to.
More interesting, my lord, one paragraphs 9, my lord. One line is very important, my lord. My lord, after 3-4 lines, my lord.
You read the line.
Yeah, but the petitioners cannot make to suffer due to the delay fault of the state. Public SLC being considered their applications.
No, that is okay, but
State's fault, my lord, the petitioner cannot be.
state fault is okay, but if there are no vacancies, what to do? Unless it is your claim that is notwithstanding those vacancies, subsequent vacancies will have to be dealt with. Is it your pleaded case?
And,
No.
my lord, that complicacy arises, my lord, due to the fault of the state, my lord. Because my case is.
Where have you pleaded that? Let us see your pleadings.
Yes,
Where are your pleadings?
they have done, the respondent has done their part. There is no delay on both for.
My lord, paragraph number 6, page number 7, my lord.
Hmm.
Number one line, paragraph number 6, my lord. After the state authority has not considered the cases of petitioner in time, due time, and clerk together the various PLC recommendations in one SLC meeting. Therefore, the evening complicacy has been arises to consider the case of the petitioner. That due to the negligence or omission on the part of the government, the petitioner cannot support.
There is no negligence on the part of the respondent for the they have already placed it and they have considered it and inspected. Why there is a negligence? And it is
Which department are you applying for?
I'm
PNRD.
PNRD. So in PNRD department, is there no regular recruitment process? Since the time of your death of your father? You did not participate.
no,
Why? Why? I don't think we can pass any orders here. Effectively, unless you are pleading. To that effect. Your only ground is state is at fault, delay. Then there are no vacancies. Where will the vacancies be created from?
Finally direct the SLC to any accommodate any other vacancy.
No,
How
no,
that can be? It is scheme, these are not a mode of appointment. Compulsion appointment is the scheme only the two side of the financial ethics only. Is it 24 years?
you'll have to satisfy all that financial hardship, etc., everything. Where are they?
Nothing,
Nothing,
he is now aged about 48 years.
how you survive? What are you doing?
In the BLC manuals, my lord, it has been written due to my poor condition, my lord. Page number.
Which year?
99.
Then? From 99 to 23 or 2019, what have you been doing? How have you survived? You must be married. You have children.
48
How are they
years.
surviving? You come back with a better case. Someday.
Yes.
Heard learned counsel for the parties. This petition has been filed by the petitioner,
My notice may be.
pleading for compassionate appointment in view of the fact that his father, who was an employee, who was working as a tax collector in Anandapur Gaon Panchayat under the CEO, Karimganj Zila Parishad, Karimganj, in PNRD department.
My lord, I am sorry to interrupt you, my lord, one thing. My lord, coordinate length of this court, my lord, consider 99 days or something.
Rejected.
I have also judgment, my lord, and contempt proceeding also, my going, my lord.
Then why are you holding on to the judgments?
Another case.
Huh?
Not my case, my lord, another case.
You give the judgments. What is the use of the judgments if you do not place? He was working as a tax collector in Anandapur Gaon Panchayat under Chief Executive Officer Karimganj Zila Parishad.
Can I watch 9 minutes, please?
For what?
My lord. This is the case of 99.
Your case is not rejected on the ground of delayed submission. Your case is rejected on the ground of lack of vacancy.
This is the case of 99, that's why. It's the old case, my lord.
No. Merely because your case is 99 is it is not rejected. You have not submitted the fact that that you are still reeling under financial hardships. The vacancies position available. If you had obtained this copy by RTI, why under RTI you cannot obtain the vacancy position? You must be vigilant in gathering ammunition for your case.
That I can take vacancy position, any other date, my lord, fix.
No, so far it's
Any other date.
Umesh Kumar Nagpal case is concerned, my lord. My lord, this case say, my lord, compassionate appointment has to be tried over a certain financial crisis and not to provide appointment. And mere death of the employee does not attach to his family for compassionate appointment. Authority will consider family is unable to meet financial crisis. After length of time, compassionate appointment is permissible. So there is so many judgment, my lord. This case is after.
You have no case. You have no case. Did you file any contempt against the earlier
No, my lord.
order then?
Kindly fix any other date, I will say this is your lawsuit, my lord.
In what respect?
My lord, the vacancy position, my lord. I will take Roatin. But I will take Roatin.
No. We'll fix it on Friday. We'll give you some time. Think over it. List on Friday, the request of the council. You have no case. Sympathy does not invite orders from the court. You must have you must make out a case on the basis of law.
Item number 7.
Yes, yes, yes.
Pursuant to the advertisement dated 13/2017, it is not applied for the purpose of Assam Industrial City. And therefore, they participated in this election process. And Lordship in the year 2022, or Lordship selected for public. Their name was not included, Lordship. They are basically agreed by the Lordship mark within the weekend and the Lordship extracurricular activity, Lordship.
So there is a series of cases, which my understand is also there in. It is fixed on 31st year. The leading case of the main case is Vikas Bonia lawsuit, WBC 3734 of 20.
It is submitted by the learned counsel for the parties that similar matters are fixed on 31st
August.
of August. Accordingly, let this matter be listed along with those bunch of cases where the lead case is WPC number
3734 of 20.
3734 of 22.
Lordship.
22.
Lordship, this is record will be for the written,
Let it come together. List on 31st.
Item number 8.
Yes, Mr. Bogor.
Yes, please, Your Lordship. Lordship, this matter pertains to promotion, Your Lordship, from the post of librarian to the post of junior information officer in the Directorate of Information, Public Relations and Printing and Stationery Department. Lordship, here, I would like to first come to the DIPI department. Lordship first issued a advertisement dated 30/10/2018, which is an Annex 1, page 22 and 23. Your Lordship. The advertisement, Your Lordship, at page 22. According to this, Your Lordship, the petition applied and they were elected, Your Lordship. And Your Lordship will come to page 31, that is annexure 3, that is the joining. Your Lordship, 8/3/2019.
No, what is the issue of first
The
tell
issue
us
is
there?
regarding, Your Lordship, the issue is regarding this petitioners are currently serving as librarian in the DIPR. And my lord, what has happened is certain blue-eyed candidates have been favored, which is the respondent number 7, who has been appointed to the post of junior information officer. And here, my lord, the particular issue is that the person who has been appointed as junior information officer, that person is a translator. According to the rules, Your Lordship, will come to the rules directly, Your Lordship, given copy here. The rules, Your Lordship, is the Assam Information and Public Relations Service Rule 1986. Your Lordship. These rules, Your Lordship,
You are now what say agreed by the position in the gradation list.
I am agreed by the gradation list. I agreed by the promotion made to the respondent number 7.
7.
And also I am agreed, Your Lordship, I have also placed I'll come to that, Your Lordship, is the incumbency list, where there are vacant posts and still we have not been appointed. We have given repeated representations we have made before the authorities. But
And
they have,
who are respondents 8, 9 and 10?
Your Lordship, respondents 8, respondent 7 has been promoted already. Respondent 8 and 9 will be promoted very soon. We are Your Lordship, facing, there is an anticipation. I will come to that, Your Lordship, but I have to place the facts of the case.
And 10?
10 also, Your Lordship, is not yet promoted, but will be promoted. And all these people are translators. Your Lordship. The rule, the Your Lordship comes
What
to-
do you want today? We are not going for a final
Lordship.
disposal. Tell us what you
Your
want.
Lordship, I want, Your Lordship, that 2 posts should be kept vacant, Your Lordship. Lordship will come.
How many posts are there?
Lordship, there are now 6 posts vacant, Your Lordship. Lordship will come to page 60. Lordship will come to the incumbency list. 59. Lordship. 59, Your Lordship, relevant. 61, 61. Page 61, Your Lordship, is the junior information officer. Here, Your Lordship will come to serial number 16. 16, 17, 18, 19, 20, 21, 22. These are all vacant posts at the moment. But Your Lordship, before that, I just want to show Your Lordship one thing, Your Lordship.
You'll be promoted from which post?
from librarian, that is what, the rule is very important over here.
Uh,
Now, you will kindly come to first, you will come to page 4 of the rules. That is rule 5. Rule 5, page 4 here. Here, method of recruitment.
hmm,
Here, recruitment to the service shall be made in the manner we are concerned with 5(2), your chief, recruitment to the cadre of junior information officer in class 3 shall be made by A, 2A. We are concerned with this structure, promotion in accordance with rule 11, 12 and 13 against 50% of the strength of each cadre. Now, after your chief, we produce this, kindly come to rule 11, that is promotion.
hmm.
Rule 11 specifically states that promotion 11(2), subject to suitability as may be decided by the commission and set forth in the rule 12, and also subject to possession of qualification and experience as prescribed hereinafter, an officer shall be eligible for promotion from one cadre to another of service in the manner provided below. This is the category of how a person is to be promoted. So, Lordship, we are concerned with 5. From journalist, sub-editor, proofreader, and librarian. Lordship, mark this, librarian, to junior information officer. Lordship, the rule is categorical that to be promoted to the post of junior information officer, these 3 posts, cadres from these 3 posts will need to be promoted, not a translator. So here, journalist can be promoted, a sub-editor, proofreader, and librarian. Now, Lordship will turn to
The journalist is in which cadre?
journalist is a cadre, Lordship. It's a cadre special, it's a cadre in the thing.
It's a- where is the cadre strike? In the rules? I think
Class 3, Lordship, it is.
Schedule 1,
Schedule
page
1.
23.
Class.
You are asking for promotion to which post?
Lordship, I'm asking for class 3. I want to join class 3, that is junior information officer.
Junior information officer.
1D. So it shall consist of cadre of junior information officer, which shall include assistant editor of publication, assistant publicity officer, press research officer, manager of publications, script writer, publication assistant, subdivisional information and publication officer. Now, what happened, Your Lordship? The respondent number 7 has been promoted to the post of the public research officer. She cannot be promoted. She is a translator. Lordship. And you see, Your Lordship.
No, where is translator in the cadre?
It's not mentioned only. It is
So
not.
are you saying that this is a next cadre post?
I think, Your Lordship, because the rule is completely silent regarding translator. So what
You come to page 23, schedule.
I know.
Schedule 1,
Schedule 1.
page 23 of your rules.
Yes, yes.
It shows the strength of each of the service and time scale of pay.
I know.
So where is your post now? Serial number?
Lordship, we are librarians at the moment. We are librarians, we are not yet officers. So when after we serve, we give 3 years of service, we are eligible for promotion and we have passed all our departmental examinations.
You're seeking promotion to which post?
Junior information officer.
Where is that post referred to in the schedule 1?
You know, so all these posts, script writer, publication, assistant publicity officer, all these are posts of.
Page number 23.
Yes, the 24. 24, Your Lordship says, assistant publicity officer.
Where? Yes.
Yes,
Assistant publicity officer. Yes.
Your Lordship, all these, press research officer,
Hmm.
then manager of publications, if you also again turns to page,
So you are eligible for promotion to any of these.
any of these. So Lordship, come to Lordship, rule 3, class, cadre and status.
Hmm.
There rule 3, 1D.
Hmm.
Classes, it shall consist of the cadre of junior information officer, page 3 years.
Hmm.
You've got class 3.
Yes.
It shall consist of the cadre of junior information officer, which shall include assistant editor of publications, assistant publicity officer, press research officer, manager of publication, script writer, publication assistant. So it comprises of AIC.
And where is library?
Librarian also is a post, which is not class 3, below class 3. So they are eligible for promotion from librarian. That is why the rule 11(5) comes into play. Because this is a librarian in 11(5), again we can read promotion. 11(5), page 9.
Hmm.
There you know, subject to suitability as may be decided. Page 9. Promotion.
Yes.
subject to suitability as decided by the commission as set forth in rule 12 and subject to possessing qualification and experience as prescribed hereafter. An officer shall be eligible for promotion from one cadre to another of the service in the manner prescribed below. So, my lordship,
So you're at serial number 5.
correct, the rules are specific, your lordship, that to be promoted to the post of junior information
All
officer.
right.
It has
All
to
right.
be.
Yes, Mr. Bora.
This page you also be also focus on this. Because I have to see instructions on this particular issue. But also if your lordship refers to annexure 2, in page 24.
Yes.
The first select list of the petitioner, including the petitioner, as well as the private respondent.
Hmm.
Now the private respondent is were placed from serial number 2, 3, 4, and 5.
Hmm.
And the petitioners were placed at serial number 10 and 11.
Hmm.
So most probably they are senior to know the petitioner. As per the select list.
Lordship, can I,
I have to seek instructions on the petitioner.
lordship, that is a wrong statement being made. Lordship, please come to, lordship, please come to
Don't say wrong statement. Don't say wrong statement. He made a statement. You may disagree with it,
Lordship,
but you say wrong statement unless you have contra information.
lordship,
Yes.
to annexure 6. Annexure 6 is the radiation list, lordship.
Annexure 6. Page number,
Lordship.
where is annexure 6?
Serial number 7, lordship.
Page number
Page number 36, lordship.
36, yes.
The respondent number 7 is at serial number 7, lordship, Mosuri Bhattacharya.
Hmm.
She has been appointed, she's a translator, lordship.
Hmm.
She has been appointed on 8/3/2019.
Hmm.
Date of joining in the government service. After that, lordship will see the respondent number 8, who is serial number 8.
Hmm.
Himanshu Lohakar, who's again a translator.
Hmm.
He has been appointed on 08/083/2019.
Then,
Now next comes the respondent number 9, who's Manoj Kalita, translator. Again, he's a translator. He's been appointed on 8/3/2019. Next, lordship, the petitioner, Sumit Paul.
hmm.
He is a librarian. He has been appointed on 8/3/2019, the same date. Fourth, then lordship will come to respondent number 10, who's at serial number 11, Rubina Islam.
Hmm.
She is a translator again. She has been appointed on 8/3/19. Then after that, my lord will come at serial number 13. Neelam Saikia, who is the petitioner number 2. She has been appointed, she is a librarian, and she has been appointed in 8/3/19. All of the appointments have been made together, your lordship. Moreover, petition number 1 and 2 are librarians, and they are eligible as per rules, your lordship. The respondent authorities divorce the rules have basically, your lordship, appointed a blue-eyed candidate. Lordship, that is the petitioner number 7, respondent number 7 to the post of junior information officer. And now what happens, your lordship, after turns to page 37, the next page. 37, which is the second gradation list. Here, your lordship, what has happened after flips again, lordship, comes to page 39. Lordship. This is the notification where respondent number 7 has been promoted. Page 39.
No, page 36 is the
The second,
provisional gradation list.
the first one.
Now, where is the subsequent gradation list? Final
Subsequent
gradation
is
list?
37.
37.
There might not, but prior to the subsequent to the first gradation list,
Hmm.
they appoint, if you also come to page 39, 38 to 39, they appoint. This is the MP notification, 12th April 2022, at page 39.
No, first let us finish off with the gradation list.
Okay.
So initial gradation, provisional gradation list is at page 36,
36,
then final is at page 37.
37. So in
So at
between.
37 show us your position.
When 37.
Serial number 1, who's serial number 1?
Serial number, they have made the translator. Who's the respondent number 8?
R8.
R8 and R9 are serial number 1 and 2. I have been, petitioner number 1 has been made serial number 3.
Hmm.
And number 4 is respondent number 10. And petition number 2 has been made serial number 6. So the gradation list also, they have made not according to the state. All of them have been appointed.
Have you put the gradation list to challenge?
Yes, sir. I put with the trade of that. And in most simplistically, Rachel, all of them have been regularized on the same day. That is, that also annexed.
You had all joined on the same date.
Yes, sir. All have joined on the same day. And confirmation also was given the same day. But they are translators, Rachel. Translators, nowhere in the rules has been mentioned. Translator cannot be promoted to the post of junior information officer. It has to be rule specific. It has to be a journalist, it has to be a sub-editor come proofreader, or it has to be a librarian. And here, my lord, I have completed all the, I complete all the requirements. They have made an error, there is an error apparent on the face of record. They have selected a blue-eyed candidate, my lord. Subsequent to the main gradation list, the first gradation list, they
I
appoint.
heard Mr. A. Pupan, council petitioner, and Mr. D. Borala, council respondents. You appear for all respondents,
No, Rashid, 1 to 5.
1 to 5.
Or 6.
6, Mr. So and so appears for respondent 6. This, the petitioners before the court are appointed as, are working as translators,
Petitioners are working as librarians.
librarians. Where are you working as librarian? Where are you working?
Not sure, I'm working in the Directorate of Information, Public Relations and Printing and Stationery Department. DIPR, in short,
Both the petitioners
both the petitioners in
are
headquarters.
working in under the, as librarians, under the Directorate of Information and Public Relations. So. Then the council of the petitioner submits that the petitioners having put in the required years of service are now eligible for being promoted to the next higher post of
Information.
junior information officer. Then the council to the petitioner has referred to the Assam Information Public Service, Public Relations Service Rules 1986. Stop, as per rule 3. As per rule.
Fine.
As per rule 3, the class and cadre are specified and the librarians are shown as they are not as class 3.
No, they're not officers. They're eligible
The
for.
post of junior junior information officer is shown as a class 3 post. Stop. The manner of promotion is prescribed under rule
11.
11.
11.
Say rules.
Fine. The method of recruitment.
Under
is-
11, under rule 11(2), it is the feeder category posts are shown from which the promotion are to be effected in the next higher post. Under clause 5 of the same rules, it is specified that from journalist, from a sub-editor, come proofreader and librarian, the next higher promotion will be junior information officer. Stop. The grievance of the petitioners are that the petitioners being having rendered their services as librarians, they are required to be considered for the next higher promotion to the post of junior information officer. Stop. However, the private respondents who are working as what
Yes,
journalists,
translators.
translators, have instead been promoted to the next higher post of junior information officer.
More specifically, the respondent number 7.
More particularly, response 7 and 8.
Only 7. 8 and 9 will be promoted. The gradation is there.
7 stop. Respondents 8 and 9 and 10 are likely to be promoted shortly. The council for the petitioner submits that this promotion effective to respondent number 8 and the proposed promotion to respondents. Sorry, who was promoted? 7.
7 was promoted.
7, and the proposed promotions to respondent 8, 9, and 10 are all contrary to the rules, more particularly rule 11 to 5. 5 is Roman 5 of the so and so rules. Being agreed, the present writ petitioner is before the court. The writ petitioners are before the court. It is submitted that the private respondents 8, 9, and 10 are likely to be promoted to the post of junior information officer And to the best of the information available to the petitioner, as on date, there are how many vacancies? Six. Six vacancies available. Okay. But then why do you need a stay? Because there are four persons, four respondents. You are two.
So there is a general anticipation, they will amend the rules also, Lordship, they're planning to, they translate as a time limit. And Lordship, no, Lordship, they have, reversed the rules, they have done it, Lordship, and they are not promoting us. And
There are
there are other
Mr.
translators-
D. Bora, learned counsel for the respondents submits that as on date, he has no instructions, he would like to obtain the required instructions. Accordingly, the notice be issued returnable 4 weeks. Since learned councils have entered appearance on behalf of the state respondents, notices are waived, however, extra copies will be furnished within the course of this week. Steps on the private respondents 7 to 10 be effected by registered post within 1 week from today. A notice on the interim prayer lists the matter after the returnable date. Till the next returnable date, two posts, two vacancies, two posts in the header of really, two posts in of what? Junior assistant,
Junior information officer.
junior information officer shall not be filled up without legal report. List on. First of September. First of September.
Supplementary for motion item 53 and 54.
Yes.
This is regarding compassionate requirement. This is my intensive my lordship, I lost my mother my lordship. And also during my minority my lordship, age of minority, my father died. On 8/1/2019.
Somebody was supposed to place some judgments. What is that?
I have referred some of the judgments.
Let him explain.
What exactly happened? When did your father die?
My lord, my father died on 8/1/1984.
Hmm.
At that time, I was minor my lordship.
Your mother applied.
No, my lord, my father died during my infancy.
Okay, so after you obtained majority, you applied.
Yes, my lord.
And by that time, how many years have passed?
My lord, I attained majority on 20.
So after 10 years,
2001.
after 10 years,
No, my lord, 2001. my lord.
2001, okay.
After attaining majority on 28/2001. I didn't have any siblings. My mother died during my infancy. My father died during my majority, my lord. And somehow, my lord,
Now,
I
what
completed-
what has the SLC done?
my
Or
lord,
DLC, who has rejected?
SLC page 25, my lord. Page 25 is the dividend portion there. Serial number 2, my lord.
Late submission.
Late. So my contention is that, my lordship, there is, therefore some of the judgments, my lordship. In case of minority, my lordship, at the time of my father's death, I was minor, my lordship. After attaining minority, my lordship, majority, I submitted my application. In these circumstances, my lordship, Honorable High Court, even Honorable Supreme Court of India, passed some judgment, my lordship, in favor of the minors.
Who has furnished this then? State of Manipur? You have done. Let us hear, see their judgment.
There is no particular rule, my lordship, regarding the situation when the guardian harness during minority of the children, my lordship. In these cases, my lordship, Supreme Court of India, my lordship, and this from those and other cases also, they have they have considered. My case is that, my lordship, where my mother also died during my infancy, I have no siblings.
Santosh is not applicable because Santosha's provisions were different.
Yes. Other governments are also there.
Then Khatim Hussain, yes.
Even this honorable court, my lordship, time and again considered, my lordship, I have submitted those judgments, my lordship.
Hmm.
Time and again, my lordship, given judgment in favor of the minor who submitted application after attaining majority. In Abul Kasim Barwaya and Salimul of Mahindra. Also, as my lordship, Azad Hussain Lashkar, there are several judgments. If I do the petition, during sentence, the rejection order was communicated.
Then,
My lordship. My only submission is there, my lordship. During minority, my lordship, I lost my father, even my parents, my lordship. I didn't have any siblings, my lordship. I worked as daily wage laborer. I completed my education, I attained my minority, my lordship. I submitted application. The DLC, after considering all the aspects, my lordship, they recommended for my appointment, my lordship. And whereas.
why don't you take us to the judgments that you want to rely on?
Yes, my lordship. I have relied all the judgments, my lordship.
No, you rely
Like F also, my lordship.
Ah.
Like F.
like F,
Like F.
yes, like F.
It is also, my lordship, regarding minority, my lordship.
Yes, Mr. Hall, what do you say?
Who is the matter?
What do you say?
My submission, my lord.
Like C also. my lordship.
Yes, your submission.
Let him finish, my lord.
Huh?
Not the finish.
He has relied on judgments passed by Supreme Court as well as by this court.
Like C also, another judgment.
My lord, I will not place this good judgment, my lord.
No, but what do you say in view of this Abul Qasim? Abul Qasim has considered your judgment. Any appeal has been filed against this.
No, my lord.
Well,
But, my lord, there is no coordinated, way, my lord. I have good judgment.
you have placed that,
I'm placing it, my lord.
Manipur,
Money.
and that has been considered in Abul Qasim. That is what I'm saying. Have you gone through the Abul Qasim? Go through these judgments. Go through these judgments.
My lord, before that, my lord,
Hmm.
let me put it, my lord.
Yes,
My lord.
and what about Khadim Hussain? There is also Supreme Court.
My lord. But that is in a different context, my lord.
What different context?
Where mother applied. Then she withdrew, my lord.
Same thing, the minor, he was a minor.
No, my lord. Mother applied, mother withdrew, then my lord. Then the candidate applied, my lord. That's all.
Where?
That in Kasim's case, my lord.
Khadim.
Kasim, my lord.
Khadim, he was a minor.
My lord, here, let me put it in perspective, my lord, this is my case. So, never his case, my lord, no issues. But let me.
No, what do you mean, no issues? We are laying down laws. We can't have a law which either allows or disallows. It has to be streamlined properly.
My lord,
For which you need to assist the court.
my lord,
Yes.
let me put it, my lord. My lord, first I will go to the OM, my lord, page number 31.
OM. Is the OM available here?
Yes, my lord, in page number 30 on the
Yes, sir.
restriction, my lord.
Yes.
That is in my lord, 3982 of 23.
Hmm,
Let me take it.
hmm.
My lord, to find in page number 32. It starts with 3. The duration on which my lord application will be completed. By a candidate, my lord. It is 1 year. Every eligible dependent seeking appointment under the OS shall make application for appointments on completion ground in the respect form with all the enclosures within 1 year date from the date of the. So, my lord, this is the fallout, my lord. This was in the fallout of my lord 2010 for GLT
My lord, here, my lord, this honorable court has laid down, my lord, that the time prescribed limit, it has to be 1 year. Our court, my lord, honorable court has laid down the law, my lord, that it has to be 1 year. And that this poem is fall out of that judgment, my lord, the direction. Now, my lord, I am coming to the Supreme Court. Whether a minor, my lord, can we keep a seat for him, my lord? I will just read, my lord, para 11. My lord, I have the book, I can,
Of
my lord, 2003, 7, SSC 511.
name of the parties,
Name of the party, my lord, State of Manipur versus Mohammed Rajuddin.
yes,
My lord,
copy is here.
para 11, my lord.
Hmm.
It's initially it starts with that, my lord, gives of the minor, my lord. In para 11, my lord. In Sushma Gohai Patna of India, it was observed that in all claims of appointment on compassionate ground, there should not be any delay in appointment. The purpose of providing appointment on compassionate ground is to mitigate the hardship due to the death of the breadwinner in the family. Such appointment should therefore be provided immediately to redeem the family in distress. The fact that the work was a minor at the time of death of his father is no ground unless the scheme itself emphasizes specially otherwise. To state that as and when such minor becomes a major, he cannot be appointed without any time consequence or limit. The above view. So, my lord, here Supreme Court is, while categorically, my lord, is laid down that we cannot, authorities cannot keep a seat vacant, by lord. That when he will grow, when he will attain majority, then only he will be
What
appointed.
is the scheme? What is the purpose of the scheme?
Scheme. Now that is, but in the scheme, my lord, it is 1 year. Our scheme,
What is the purpose of the scheme?
part of the scheme is to, my lord, to give a financial relief to the family, those who have lost a breadwinner immediately.
Exactly.
Exactly.
But in a
Yes,
given
my
case, your scheme requires that you person has to be minus cannot be appointed, or there is no specific provision for that.
My lord.
Now, here in a given case, his father died, then his mother died, no sibling.
Father died in my father died in 2009.
Hmm.
No. 1994. And father died in 1994, my lord. And in between, mother was the mother would apply for mother would apply.
Prior to my brother's death, during infancy,
Mother also died.
before that.
Mother also died. So, there is nobody. He is a minor. Then what is the provision? What should be done?
My lord, there is no provision for minor hearing in the scheme. In point, there is no scheme, my lord. Our scheme is, my lord, some next week has to apply within a period of 1 year, just for the case. That is 2010 4GLT, my lord. That is what we.
Where is that? Where is that clause? Where is that clause?
Close it, my lord, in page number 32.
32,
32, my lord, 3,
3.
3, my lord.
Every eligible. Where is the eligibility? If I.
That is the matter Supreme Court comes in, my lord. Here Supreme Court says that, my lord.
See, you come to page 31, come to your clause number 2. So it says, these are the dependents, eligible members, dependent family members.
Person who,
It includes a son or a daughter.
my lord.
There is no mention of major or minor. Number 1. But in clause 3, it says every eligible dependent.
My lord.
So eligible means clause number 2.
But it doesn't say that, my lord, when he becomes eligible, was why not in this matter? Father died in 94, now we are in 2023.
No, I think your scheme is making it open, it is not clear, so going by the scheme. It makes it open for a family member to apply. Whether that person is eligible to be appointed or not, is the call you take. But whether you can reject it on the ground that he is a minor,
No, we said when late submission. In our rejection, we said late.
correct, late submission because he submitted after he became a major. His case could have been considered and on the ground that he was a minor at the relevant point in time. When did your father expire?
My lord, my father said 8/1/1984.
8/1.
I attained majority on 28/2001. My mother died during my infancy. No pensionary benefit, nothing we got. My grandfather looked after me, then grandfather also died. I daily wages were like this.
When did you apply?
My lordship, my application on 28/2001, my lordship, annexed page 15, my lordship. I appeared for interview also, my lordship, 2008, my lordship, I called for to annex page 17.
What interview?
Recruitment really, my lordship, regarding police department, recruitment.
How is it relevant for compassionate appointment?
They asked me to appear for recruitment really, my lord, page 7.
You are rejected by SMC or DLC?
DLC, my lordship.
DLC.
Is OC, page 17. we received. And then I participated in the recruitment rally also. my lord. And thereafter they recommended me.
What is that page 23?
Page 23, it's a minutes of the SLC, my lord.
Why was
It is impugned SLC.
minor? Here is the thing again, minor. It is then minor of 2011.
My lord, I go to, I
2011, and he comes in 23, challenging the order.
Nothing has been communicated after I filed the first petition. In affidavit in opposition, this was the next, then I filed in challenging the.
No, it will hear it again. Please on. This will require some examination. We will have it on 17th August. 17th August. Thursday. List on so and so. As the matter will require some examination. In view of the judgments placed by the learned councils for the parties. 8, sorry. 17.
Item number 55.
Medical. I. Whatever. Yes, page number.
Page number 3.
3. 3 is the name.
Yeah.
He is absent. He is absent.
Yeah.
Yeah.
No, that will be page 4.
Okay.
Then when the fourth of the I speak. The light eye. After our verification, 0.25, which according to the specialist, probably not. In the left eye, it's is blind from the left eye. Perception of light is negative. PL means particle negative. Now, there is a guideline that in order to be a disabled person, under this category. Even if he has one eye from which he can see, then he cannot be considered. What do you find that page 14? I think let's see there is a chart.
Page 14.
Page 14. The chart says, my lord, the
But
better.
there is no page 14 here,
Here I have, well, the last page.
last page.
Yeah.
Okay,
What you see in the my lord, chart.
last page, yes.
So the left hand side, my lord, top.
Hmm.
6 to 618. This is the better eye. Now what you will see what's
That is 6 by 6.
6 by 6 to 6 by 18.
That is normal.
It's normal.
Hmm.
Now the word side,
Hmm.
the next column,
Hmm.
6 by 6 to 6 by 18 is 0. 6 by 24 to 6 by 60 is 10%.
Hmm.
Less than 6 by 60 to 3 by 60 is 20%. Less than 3 by 60.
No light,
No light perception. It is 30%.
no.
And the last one, disability category is 19%. The petitioner comes under this category. It will be 30%. Why I am saying is that the lordship may kindly turn to the form 3 in the transfer.
Form 3,
Yes, along with the disability certificate that has been issued by the one director.
Form 3, yes.
Here lordship will see whether.
Blindness in left eye. Left eye.
Yes. It is 6 by 18.
This is by whom?
This was issued by the one director. Thus, I want to point out.
No, this is an application by him only.
Yes, sir. Of 2017. ma'am.
Hmm.
Also, you see, my lord, in the right hand corner down below.
Hmm.
Here, the my lord, figure is 6 by 18.
Hmm. 6 by 18, yes.
So, but my lord, blindness is in the left hand.
Hmm.
Now, my lord,
So 6 by 18, 6 by 18 is what?
comes to, lord, you will see, my lord, in the first column, the last page.
No, 6 by 18 is for
Yeah.
right eye.
Right eye. And my lord, one eye, my lord, 9.
Left eye.
So it will be 30%. Below that, my lord, 6 by 20, 6 by 60, it is 40%. It starts, it goes down, 60, 40. So he will be, my lord, 30% from their own certificate, that was issued.
Where is this schedule available?
What you will find it in one notification, gazette notification issued by the central government. This is followed by the authorities.
You don't have that.
But the entire file is not being given. But Dr. Can you turn to my page, again, my lord, there, my lord, form 3. Then the next page,
Hmm.
the continuation of the form. What you will see is there, my lord, the para 3. Para 3, it says, my lord, reassessment of disability is recommended after 1 year. This is part of the petition, my lord, petitioner has filed it. And this was issued in 2017. Date of issue was 28/8/2017. Thereafter, my lord, petitioner have not gone before the authority for reassessment. Probably by now, my lord, otherwise also.
Yes, you have to bring it on record.
Fine.
Let him get an opportunity of rebutting. As per the notification, you are 30%.
My lord, can you see page 28? Paragraph 2.
28.
Yes.
Yes. Yes.
The condition is non-progressive.
Hmm?
2, my lord, paragraph 2.
Hmm.
This condition is non-progressive.
Yeah, non-progressive, not likely to improve,
Yes,
but in respect of your left eye,
left, yes,
and the left eye as per the notification is 30%.
but my lord, as per, my lord, the page 26, and it's an AMA.
Hmm. Hmm.
It is my lord, can you see?
No, that he is given, you have to now, Mr. Gogoi, you have to take up this issue with your officers.
Yes,
On what basis they are issuing this.
yes.
So therefore, we have asked him to bring it on record. Mr. B. Gogoi, Learned Standing Council Health, has produced the instructions. I furnished the instruction, placed the instruction before the court. According to the instructions received, the medical condition of the petitioner, disability condition of the petitioner has been found to be 30% in view of the prescription laid down and in the visual impairment certification criterion gradation specified under clause 19.3 of the notification. Who has issued this notification? Stated to have been issued by the Government of India and which is followed across the country, including the states. Stop. The medical examination of the petitioner, as per the documents available, revealed that he is blind in the left eye, but his vision in the right eye is normal. And therefore, as per the chart available at clause 19.3 of the same notification, loss of vision in one eye is considered to be 30% impairment. And the person is to be placed in disability category 2. So, under such circumstances, there is no infirmity in respect of the. There was a medical examination by the department subsequently.
Subsequently by the in GMCs.
There is no infirmity in the examination, medical examination of the petitioner, under which he was found to be 30%. Contrary to the certificate issued by the Joint Director Health Service, where his disability has been shown to be 40%. Stop. In view of such instructions in place, this court considers it necessary to direct the Standing Council to place these instructions by way of an affidavit, so as to give an opportunity to the petitioner to debate if so required. Mr. Chauhan, Standing Council, appears for the petitioner, and the matter is deferred for 2 weeks.
The notification was issued by the Ministry of Social Justice and Empowerment. And it is dated by the 4/1/2018. It is
Yeah.
mentioned in the certificate at page 26.
Page 26.
Yes. You will see at the top, the Ministry of Social Justice and Empowerment. Now, my lord, in it is para C. Last line, notified by Government of India by SO 76E dated 4/1/2018. That chart is there.
That clause 19.3 is a part of the notification issued by the Government of India, Ministry of Empowerment, Department of Empowerment of Persons with Disability, Ministry of Social Justice and Empowerment, Government of India, YD, SO, stop 76 within bracket capital E dated 4/1/2018. List after 2 weeks.
In the meantime, there is some protection between.
What protection?
My lord, the 10 medical group, my lord, large scale irregularities have been going on. Kindly see one thing, last.
So let him get it on record so that you can rebut it by whatever means you want.
But in the meantime, my lord, my post.
How many posts are available? If it is, it is provided that any appointments made to the post of what?
So we are.
Chokidar under Secondary Education Department. In so far as the claim of the petitioner shall be subject to the outcome of the litigation.
Okay. For implement of party item 9.
Yes, who is appearing?
Here, the opposite party is more, I think, softly treated as respondent number 6 in the request.
Anyone for the respondents? Health department, no, public health, public health, engineering and social welfare. Panchayat. Who's appearing? Public health,
And this is transplant disability candidate, if he is selected on merit, he should not be adjusted against the.
yes, Mr. Bora, we are recording your name.
Yes, sir. That's number two, I can.
No, since nobody is there, we are recording your name. Oh, Public Service Commission is here, respondent 4. You have no objection? Heard learned councils of the parties. Mr. Bora appears for 1, 2, 3 and 5. Mr. T.J. Monto assisted by the senior council assisted by Mr. So-and-so appears for respondent number 4. So we are screening who's appearing for PNRD, you did not send up. MS so-and-so appearing for respondent number 3. This application has been filed seeking implement of the opposite party to be implemented as respondent number 6 in WPC 4903 of 2023. It is submitted that the same respondent number 6 was the candidate who was selected for the post of
Supposed to
assistant engineer, to which the petitioner / applicant has claimed has staked a claim for selection and appointment. Stop. Learned counsels for the respondents do not object to the prayer made for implement accordingly. This IA stands disposed of. The opposite party, so-and-so, is permitted to be included as a respondent number 6. Amended post title be filed by the learned counsel to the petitioner before the date set.
It's single man who can directly file it.
No, you have to file it,
Right.
not now. Upon the amended post title being filed, the registry will make necessary amendments, alterations on the basis of the amended post title filed in the petition 4903/2021. And thereafter, the matter will be listed after 1 week. After 1 week. Then in WPC 4903, right, in view of, I disposed of, it. In view of order passed in ISO and so. Give the name, what is the name? Football Chakraborty has been directed to be arrayed as respondent number 6. Subject to the petitioner filing the amended post title before the registry. That's subject to say directed to be arrayed as respondent number 6, and the petitioner is also directed to file amended post title to the matter be listed upon receipt of the amended post title by the registry.
For admission, item 10.
Proceeding was initiated against the petitioner.
No, but why don't we take up the top of the list matter first? You are there.
Item number 1.
Whatever proceedings has happened. Penalty now might not will be do the withholding of increments.
Where?
In this case, the item number 10.
Oh, 10.
But only thing cannot.
You are still at 10.
No, Manoj, just the Manoj can asking Manoj, only thing here what is Manoj can grant. The penalty is withholding of increments. If Manoj can just read that line, Manoj.
Manoj would find it at page 49.
49.
Not yet.
It's a part of that order.
Total non-application of fine.
Yes.
The top portion, my lord. Withholding of all increments due to the officer in the current pay scale grade till his promotion to the next grade without any prospective. Now, my lord, from 2013 onwards, his increments have been withheld. Now, 10 years, my lord, he is without increments. Be the resume. Now, the penalty is this, that I will be without increments till I am promoted. But the law is very clear, my lord, till the penalty currency is there, I cannot be promoted. And there is no promotional post also, that's a different thing. This has to be modified. The difference of pay as on date. As on date. there is
How
no-
does it help you?
Because my lord, otherwise for my whole life, I'll be without increments, my lord.
Oh, you may not be promoted.
There is no promotional post, one. And my lord, if the increments deduction continues, I cannot be promoted. Let him have that instruction. My lord will have it next week. The difference of pay now is, my lord, between, there were two persons appointed.
You are appointed as what?
My lord, it's appointed as information technology officer.
And what is your next promotion post?
There is no promotion. This is the only post. It's a singular post.
Information technology officer.
Officer. There were two persons appointed. And the difference of, under the finance, my lord, taxation, commissioner of taxes.
Commissioner.
And there were two persons appointed. The difference of pay as on date is 25,000 per.
Okay, heard, Mr. UK Nair, Senior Counsel, assisted by Mr. Spencer and Counsel for the petitioner. And Mr. B. Royal and Standing Counsel Finance. Petitioner is essentially aggrieved by the punishment imposed by the by the principal secretary of Government of Assam.
1870.
By order dated 18/7/2017. So the punishment imposed was is as under page 49, first part, withholding of all increments within quotes. So, a learned counsel for the petitioner submits that the petitioner is working as information technology officer under the Department of Finance attached to the Commissioner of Taxes office, Government of Assam. So it is submitted that there is no promotional post. There is no scope for promotion of the petitioner. And by imposing the same punishment, the increments directed to be withheld will continue for life. As such, the petitioner has prayed for modification or alteration of the punishment imposed, and to that limited extent, has filed the written petition seeking appropriate orders from this court. Mr. B. Gogoi, and appearing for the respondent, submits that he would like to obtain instructions and place it before the court within
20%.
the next stage. The councils are in agreement that the matter be listed on 21st. 21st.
During the currency of this penalty, I cannot be promoted. Even if there is a post created, I cannot be.
But there is no post. How does it matter? Yes.
Item number 1.
My lord, the instructions that I have got from my friends, my lord, is that they both are working as assistant director.
Assistant Deputy Controller.
Assistant deputy controller. So now, my lord, the only thing here works.
So nothing remains.
No, my lord, the seniority issue will be there.
Let me leave it open, new department.
So because if that man has been encadred in this manner, he'll always have that, my lord, benefit. The encadrement, my lord, can.
Please for the respondent.
Their name has been shown, they have filed affidavit.
So we will direct the department to consider your claims in respect of the encadrement made in.
Because my lord, they have already in their affidavit said that that is proper. If my lord looks into the rules, If my lord can have the rules, my lord.
Rule number, rule,
My lord, at page 17 it starts,
17,
178.
yes.
Rule 3 is the class and cadre. Page 18. My lord, we'll have 3 C and D.
Civil defense.
Civil defense demonstrator and civil defense wireless operator.
Oh,
Now, my lord, we'll have 2B
2B.
or A also. Any post equivalent to a post in any of the cadres mentioned in Rule 1 and any cadre or post laid down by government to be included in a cadre of the service. So it has to be done by the government. Now, my lord would see the schedule. At page 30.
What is the stand of the respondents in the affidavit?
I'm coming to that. My lord. I'll just place this, my lord.
Hmm.
My lord, list the post equivalent to and included in the post. This is under page 3. It is civil defense wireless operator and civil defense operator.
See, these may have been amended in the meantime.
Yes, it has been amended.
Yes.
My lord will have that at page 33, 98 it was amended.
Hmm. Then subsequent amendments maybe.
No, a subsequent amendment.
How do you know your client, you are not in touch?
No, madam, when I filed the writ petition, at least when I filed the writ
When you
petition.
filed it, it may not have been there.
No, madam, the order was passed. My lord would see the order, that's my nuance, madam.
What is the amendment brought in?
Amendment brought in is, my lord. Two
Persons appointed.
to equivalent posts in so and so before commencement shall be treated to have been encountered in the civil defense demonstrator and civil defense wireless operator. So
And,
that has to be
and the respondent was appointed as a PDA.
PBX operator. It was in a higher post, master.
So there has to be some order to say that it is encatered,
Encountered, equivalent.
equivalent.
So that order has to come from the government, not from the Director General of Home Guards. Order is at page 36.
So who's for the respondent here?
For the government, I'm here.
No, for the private respondent?
Private respondent needs name.
PS Bosomotari and Boro.
They were appearing all along. Nothing.
Now, what is the affidavit filed there? What is the affidavit here?
My lord, the affidavit of the government, my lord, would find. By one Bhupati Bhushan Roy. Para 5, my lord, and para 6.
There are 5 and 6.
Lord you. Page 2. That as regards the contention of para 7 of the writ petition, this deponent respectfully begs to state that the petition is not entitled to a SLD order passed by the Director General of Civil Defense and Commandant General so and so, unless it challenges the rules as amended 1988. On that count itself, so and so is not met. It is further stated that the encadrement of the mind the words encadrement
Encaderment.
of the post of PBX has been made by the amended service rules as amended in 1998 by the competent authority in exercising the power conferred in it by law. This encadrement of the post, and for that matter, the post held by the deponent is not done arbitrarily as alleged by the petitioner. As regards the response number 3 at the top of the gradation list, as updated on so and so, this deponent respectfully states that the action of the respondents is in conformity with this so and so. That as regards the contention so and so, this deponent respectfully says that the petitioner has misconceived the law as established by the amended service rules. Be it mentioned here, they provide under sub-rule 2 of rule 5 of the opposite service rule. The post of people held by the petitioner has encountered in the civil level so and so. Notwithstanding anything contained here in above, persons appointed to equivalent posts in so and so before commencement of these rules shall be treated to have been encountered in civil legal so and so. Thus, under such provision of law, the pay scale of PBX has also been made at par with that of civil defense law since 1998. Further, in respect of equivalent, it is regularly stated that apart from pay scale, the eligibility criteria for recruitment to the post of so and so are same. Besides, the equality of services of both so and so is same pertains to disaster management. However, the petitioner has projected a distorted picture altogether in his petition in misinterpreting the established law for his own individual benefit. My lord, here the PTS operator, he is the main man who sits in the board, and all the calls that come from outside to that institution, his duty is to distribute the calls to the various authorities. Whereas
Today, is there any necessity of a PDS?
there is no necessity.
So no necessity.
No necessity.
So
So, my lord, there has to be an order on that day, my lord, when this Tribune order was passed. That power was not there. That's my humble case of the rules.
no, but they say that the rules have been amended in 98.
98, and this order is of 2010 encadering him, my lord.
No, 98 amendment again, let us take the.
Lordship, my lord would have it at page 32.
98 amendment,
98 amendment. My lord would have page 33, it starts. My lord would have 34. 2. My lord will have 2, my lord, 2C. If my lord wants the corresponding provision, that is being changed. My lord would have 3(1), my lord, at page 18. And the amendment is at page 30. Civil defense demonstrator, civil defense wireless operator. The post of civil defense demonstrator and civil defense wireless operator are included in the cadre, and the incumbent goes to these posts are interchangeable. So earlier, my lord, it was civil defense wireless operator, then civil defense demonstrator. Now those two posts have been amalgamated into one cadre. Then my lord would have 3A. That is amendment of rule 5(1). Recruitment to the post of to the cadre of civil defense demonstrator, civil defense operator shall be made by direct recruitment. Now 5, my lord, again is at page 19.
now who has passed this order at page 36?
This is by the, my lord, Director General of Police, Home Guards, Commandant General, Home Guards.
So by this order, it was entered.
Entered, which I say, my lord, can be done only by the government. And there is nothing here to show that this was done by the government, and he just, my lord, communicated this. My lord would have the third paragraph at page 36. I think that will clarify. From the department records.
Just 1 minute. The council has not to display for this. Yes,
My lord, page 36, third paragraph. From the departmental record, it is found that the applicant has not been so far encadred in any grade of the service in the civil defense organization of Assam. And if, my lord, the provision that he is, my lord, trying to quote is at, originally is at page 19. My lord will only have that, and then my lord will understand, my lord, why this is bad. Page 19. My lord will have 5(2). My lord has. Notwithstanding anything contained herein above, under sub-rule B of this rule, person appointed in equivalent post in the civil defense department before commencement of these rules shall be treated to have been encadred in the civil defense demonstrator. So, my lord, this provision was there originally when the rules of 1991 were formulated. Now, my lord would see.
so
The
what is the equivalent post of PDX?
Nothing, it's an ex-cadre, a singular cadre post. It's not provided in the rules. It's provided in the rules, my lord.
There was a pay
Lord, yes, sir, it's provided. My lord would have it at page 31. my lord.
31. 31.
It says, my lord will have 30, my lord, under rule 4.
Those PVX operator gets more money.
It gets more money.
Huh.
Gets more money. 1125 to 2215, whereas it was 20. Civil defense operator or demonstrator was 975 to 1195. Then the promotional post was civil defense demonstrator 1065 to 209.
Hmm. And that apart, that post is temporary post.
Temporary post and my lord, it's totally an ex-cadet post. That man, the person at that point of time wanted to bring this man in, so he did. And they say it was in 98 that this amendment was made. My lord, I have showed in page 90. Now my lord would come to page 34. Sorry. No, 34.
Now you're both working as
Assistant.
Assistant Deputy Controller, within the senior, is equivalent to inspector.
and who's senior?
They're both working there, who is senior?
The other one will be senior, because he got promotion much higher.
So let us close this petition since they're not here. Since they have already been, now both of you are working,
My lord, subsequently may have been promoted, but the grievance.
your grievance will now be with regard to seniority.
No, my grievance would be, my lord, that my promotion should it back to the date when that man was promoted.
Now you're asking for arrear and back wages.
My lord, if not areas, then at least the notional benefits I'll get. my lord.
Your seniority, if corrected if required, if corrected at the current post, will take care of all that.
But I will have to be, my lord, if that has to be taken care of,
Uh,
then my promotion has to be antedated.
Not necessarily.
Because here, this is the subsequent development. I had asked for interference of the order dated 9/9
So these
and the
subsequent,
gradation list.
no, these subsequent developments are not here now.
No, my lord, this gradation list,
You are asking for quashing of that order.
my lord would have page 38. For a second.
We are going through your prayers.
On prayer, yes, my lord,
You
watching
are
of
asking for quashing of that order.
order and my lord,
Director General
Director General and my lord, page 38,
and
gradation list.
and for setting aside the gradation list.
Lordship, my lord, you'll have page 38 for a second.
38.
Lordship,
Yes.
he has been now placed at serial number 1.
What
Honor
is
has
it?
got it,
Bosanto.com.
Boson Doctor. And my lord will see the remarks. Encadred by DG series order number dated 9/9/2000. So it cannot be encadred here by a authority lower than the government.
So that is what I'm saying, this gradation list will have to be redecided by the rework by the
But my
department.
lord will have to hold that the encadrement was bad. Let him stay as that. I
No,
want,
we propose to dispose it off. Reflecting in our order, that in terms of the rules, the order of the DGP does not appear to be in consonance. Therefore, now that they are both working together in the same post, the only question left would be to reconsider the seniority position in the gradation list. Now, if the order passed by the DGP is in conflict with the rules, then the department will now, notwithstanding that we do not interfere with the order of the DGP, because it may have service consequences on the private respondent who is not represented. Department will look into the matter and pass appropriate orders in terms of the rules, refixing your seniority and giving you whatever due benefits if entitled.
my lord, only thing is that that's the.
See, the whole problems in your life can be sorted out.
No, I did not be.
So you came because the court selected.
That much
challenging-
my lord will say,
Ah,
that is bad, and then my lord would only say that if that is bad, then I should be given benefits as was given to this person and my seniority is to be requested. That I think will take care of it.
We would have interfered with this order, but for the absence of the
But
council.
they were regularly being represented.
No, they were not. In the last,
Earlier in the
Dates,
matter of
they were not
predicament,
here.
they were there.
all right, we will wait for some time for them to come in the second half. Your assisting council may be available, but we are making it clear the nature of the order that we intend to pass.
My son is also sick, I've taken to the hospital.
Okay, tomorrow then.
I'll try to get hold of the private.
Yes, tomorrow business is creating problems. So it has to be today and now. So tomorrow again, we do not know how many matters, what partner matters are there. We have to refresh our memories in the evening.
Supplementary list will also come because yesterday some matters have come.
Then. And then Mr. Nair is perennially busy. He's
Never be sick.
so. All right, better tomorrow we'll give one more opportunity and if you know the councils,
I'll try to get hold.
you may request them to be present.
Much.
Matter has been heard at some length. However, in the absence of the councils for the private respondent number three. No, is it three? This four differs the matter for a day. Directs it to be listed tomorrow. Or at the top of the list. He will come at the top of the list. For disposal.
Item 11.
Or orders. For passing necessary orders. Yes,
Lordship, in this case, the father of the petitioner was working as a BFO employee, Lordship.
affidavits by Mr. Korita. You have been given time to file affidavit, you did not file. Huh? Why you need some more time? Huh? No, this some more time can be a matter of course. We'll grant you with cost. On 19.5, you've been given 3 weeks. Today again, you tell some more time, quantify the time, how much time you require?
1 week. 1 or 2 weeks.
1 or 2?
Lordship, 2 weeks.
2 weeks. So you'll pay 2,000 rupees as cost. Mr. K. Kolita.
And Galita.
N. Kolita, Learned Council for the Petitioner, Council for the Industries Departments submits that in spite of submits that further time is necessary to file the affidavit. Around on 19/5/2023, this court has granted 3 weeks time to Mr. Kolita to file the necessary affidavit. However, today when the matter is called up, the prayer for further time is renewed. Mr. Kolita submits that the affidavit will be, you'd like further 2 weeks time to file the affidavit. List after 2 weeks, Mr. D. Sharma, Learned Counsel appears for the petitioner. This is a compassionate matter.
Yes, sir. Lordship, arising out of same selection for SLC, Lordship. One of the candidates who also approached before this honorable court. His case has been disposed of by this honorable court and that order already placed in the report. In the same time, this requisition also can be disposed of by this honorable court.
Where is that order?
That order is
You are not familiar with this order? Are you not familiar with this order? Why? We go through it, we'll take it up at 2. Tell us if it is covered. Go through this order. At 2.
Item 12.
May I please, madam? You are less regarding also, madam, from your side, you want that requirement. Last development of the time to file application.
Discuss Surya.
Mother, I am taking the second file of document, my file is coming up, and I don't know what is there. Mother, it is promotion matter, mother, I have gone for the contents of the petition, mother. Petitioner never stated any one of any paragraphs, mother, that he appeared in the post of supervisor. Supervisor post is filled up by advertisement.
There is an order that you were given time to file an affidavit, either you say file or.
Thus, I have got it.
He is working as Anganwadi.
Yes, sir, affidavit, that affidavit is ready, mother.
Draft is ready.
Yes, sir, I will go it.
When will it be final?
Mother, let it be 1 week, mother. That affidavit is ready. We have sent a letter on.
What is your stand in the affidavit?
Stand is, mother. There is a provision for promotion.
There is some post directly lying vacant. Is it vacant?
Yes, madam.
Vacant, which post? Supervisor?
Yes, madam.
And under what provisions are you entitled to for consideration for promotion? Some guidelines, some rules?
Yes, madam, but I am not, next to the commission. Now, in the day.
Mother, what is the mother, it has the post of.
Yes.
25% reserve madam for one by water to supervisor. In our.
Which part of the
Yes,
notification?
our extended, my lord, in 2016, there's the advertisement. So for the post of supervisor. And he explained it for a junior, Dipani Das has been appointed as a supervisor, her case is not considered. Dipani Das appeared in the 2016 in the interview, my lord, she passed and the petitioner was not appeared in the same interview. So he did not appear in the interview, how her case may be.
Did you call her for interview?
Yeah,
Did you?
no, she did not appear.
No, these appearance will have to be pursuant to a,
Advertisement.
not advertisement. Somebody will have to accept her application or give her.
No, advertisement is made, because like, everybody helped by everybody work hard.
If it is advertisement, then why is it a promotion?
And if the promotion, but in promotion also the selection is not that much. Amongst them, not workers. That is the selection. So as per our affidavit, stain is there, she did not appear in 2016. There was a.
She is asking for a promotion, not for a direct recruitment.
No direct, but promotion also, there were, the scrutiny is made, my lord, among the working workers. Nobody worker. So this.
Why will there be an advertisement for promotion?
Mother 2016, mother wait.
It is a regular matter in the year 2005, 2010, or not considered. Madam.
Not considered which is to pass. And regarding age group, I don't know, I am not confirmed. So for helper and honorable worker, age is 80 to 44 years. But supervisor is, I think, maybe more than that. Like you find the mother affidavit.
I think there is a 25% reserve quota.
Is that good?
That is for promotion.
Also, for 25% reserve quota, Manoj, in 2016, 17 2016, our district level and our interview was held. On 29 and 30th of January 2016. So and so to Kalipura. Paragraph Dipali Das appeared in the interview held in 2016.
Do you have a copy of the guidelines?
He has not annexed anything.
No, your departmental guidelines, you don't have it.
No, I will correct it, my lord.
No, we have it for you. Have a look at clause number 3. Clause number 3. Clause number 3.
I will correct it. What is it? It will be into this topic is case, my lord. I will produce it.
Kindly look at clause number 3. All the candidates will be asked to submit their applications.
Yes.
Have you done so?
Anganwadi workers concerned will be asked to submit application for appearing the selection test. This selection test by the their fixed by this purpose. Giving necessary details like name, age, permanent address, Anganwadi center where they are working.
So the clause begins with asking the candidates to submit.
Submit application.
So it is not on them to go and appear. You have to ask them once the process starts. That is your guideline.
Yes, they will, my lord.
Have you issued any circular notification inviting applications?
2016, I think, my lord, there is a notice.
Is it there in your draft affidavit?
Apparently, yes, they have stated. They have stated it may be mentioned here that Director of Social Welfare Assam had a written examination for the post of supervisor under 25% reserve quota amounts in the Anganwadi worker on 17 January 2016 in the district level. And already interview was held on 29 and 30 January.
How will they know if you do not permit them to apply?
For application, to receive application, definitely they will publish notice.
Well, where is that? That the notice was published, you invited applications. Where is it?
This affidavit. Does not mention this, my lord.
Will not mention, because that is the relevant issue.
There is a provision for promotion for the post of 25 reserve quota among the internship Anganwadi worker. We are native, who are meticulous and who put minimum 10 years.
Your prayer in the writ petition is for consideration.
Only considered, so.
So you consider the case.
Consider the case among with the others, one of the principle about the individual application.
Whatever means you want to apply, you apply. You consider the case. The heart, learned counsels for the parties. This petition is filed with the petition. Who is working as an Anganwadi worker at Pathal Gupa Center, number 198 on the Hadu ICPS project, Hadu, the district of Kamrup. Stop. She was appointed on 21/01/1991. And since then, she has been discharging her duties sincerely to the satisfaction of the higher authorities. So the petitioner had also completed the required training in Anganwadi training or Anganwadi training courses. So according to the petitioner, as per the guidelines, you kindly give us the guidelines again.
Well,
As per the guidelines of circulated by the Department of Social Welfare. Guidelines circulated by the notification number so and so dated 4th of June 2012. There is a provision for promotion to the post of supervisor. And 25% of the posts of supervisors are reserved for promotion from Anganwadi workers. So the details of the procedure and the eligibility are prescribed under the state guidelines. So yeah, learned counsel to the petitioner submits that although persons who were appointed subsequent to the petitioner were considered for promotion and appointed as supervisors. However, the petitioner's claim for consideration of her case for promotion to the next higher grade of supervisors have always been overlooked. So petitioner has filed representations before the authority which have remained unattended. Therefore, the petitioner has approached this court, praying for the direction to the respondents to consider a case for promotion to the post of supervisors which are stated to be lying vacant under the department. So, whereas Mr. Thesis Vatia, learned counsel for the petitioner, submits that the petitioner perhaps did not apply for the, perhaps did not apply in the required, in the prescribed format for at the time when the process for promotion had been initiated by the department. So he, however, submits that the affidavit on behalf of the department can be filed within a period of 2 weeks. So, where having heard learned counsels for the parties, this court is of the view that the prayer of the petitioner is limited to the extent that her case should be considered for promotion to the post of supervisor, which are lying vacant under the Department of Social Welfare. So, the representations filed by the petitioner, stated to be filed by the petitioner, are also enclosed to the petitions, and which are stated to have not been disposed of. So, having heard learned counsels for parties and upon that basis of the pleading, as well as a careful perusal of the notification dated 4th of June 2012, you can see that there is a quota earmarked for promotion to the post of supervisors from Anganwadi workers. So, as per the notification, the the state notification lays down the norms and guidelines for selection of candidates for appointment / promotion to the post of supervisors against 25% reserve quota from amongst the in-service Anganwadi workers. So, if that be so, and if the petition and as the petitioner is an in-service Anganwadi worker, the department is required to consider the case of the petitioner for promotion against the 25% reserve quota. For the next higher post of promotion, the post of supervisor. So, the notification dated so and so has not been disputed by the additional senior government advocate, Mr. Swanson. So, considering the prayers made and the submissions made before this court is of the view that the petition can be disposed of with a direction to the respondent authorities to consider the case of the petitioner in terms of the norms and guidelines prescribed by the notification number so and so dated 4th June 2012. So, the petitioner will be notified about the selection process, that the petitioner's case will be considered along with all other eligible candidates for her due selection for promotion to the post of supervisors as against the reserve quota of 25%. Stop. If the petitioner is found to be eligible, the said post, then necessarily the department or the competent authority in the department will consider a case and thereupon pass necessary orders promoting her to the next high post of supervisor. Stop. With the above observation, the petition stands closed and allowed. The directions of this form shall be complied with by the department within a period of 60 days from the date of receipt of the certificate copy of the order. a copy of the notification dated so and so is retained in the court file. The petition is accordingly allowed and disposed of. There is a copy regular. Only look regular that I have read.
Item number 13,
In this case, Munsif directed me to get the records and file an affidavit. But I have received some documents, which are not sufficient. In fact, I want some more time. Pursuant to Lordship direction, I returned to the department, then the bunch of paper that is received. This is not.
At the request of Mr. S.K. Talukdar, matter stands adjourned for 2 weeks.
But permit,
Ah,
I applied to RPI regarding the decision. And one letter has been furnished to me, which was written by the ARCS to the president of the co-party society. Where it is written that ARCS directed the board of directors to appoint new secretary for the next meeting. But how can you make possible?
you bring it on record if you want. You bring it on record if you think it is relevant.
Maybe
So what is your prayer? What is your prayer in the request?
where it would without removing me, the new secretary has been appointed. In the this 27/11/2020 letter by which I was asked to hand over the charts.
Any person appointed
Is already working.
already working here? Has that person been headed also party?
Yes,
But there was a status quo order granted,
status quo order was there, but even then we not
they violated.
filed.
You don't file any application for that.
This was not filed.
All right,
The private respondent has also.
then you bring it on record.
But I'll bring it on.
The request, joint request matter stands adjourned for 2 weeks, enabling the counsel for the petitioner to file an additional affidavit to bring relevant documents as straightforward and Mr. Talukdar, counsel appearing to the corporation department to file the necessary counter affidavit.
Date will be fixed.
Date 1st September. Based on 1st September.
item number 14,
Yes, what have you decided?
Hello, the petitioner candidature is still in the list, with the list of the commission and
We
appointment.
have heard that last time.
Yes, ma'am. So, from 2015, no further appointment has been given to any labor under the commission.
Then what is this statement that his name is in the list? If you have not given appointment, what is the value of the list?
Not given appointment to anybody, ma'am. So whenever.
So why have a list?
Whenever the appointment will be made and see our candidature will also.
This is a very evasive kind of an answer. Who's instructing you? Who's instructing you?
Because my lord.
Who's the officer instructing you? You're not being given correct information.
Because they are run by the circular by my lord. As
You
per-
say there is a list.
Yes, my lord.
What is that list for?
That is, I have annexed my lord.
Yes, page number,
Page number 13, my lord, of the affidavit of the.
13.
13. The forwarding letter is at page 11,
30 or 13?
1 3 man.
Affidavits. Yes,
Well, this is the list of the person, the labor who has expired and who has.
this is for compassionate, appointed on compassionate ground.
Compassionate ground, madam. Her name stands at serial number 47. So
47.
this list has been issued after 2015, madam. In last 2015, 26 appointments were made, madam, under compassionate appointment. Thereafter, no such appointment has been made, madam.
So this list is not valid today.
As my.
What is the scheme? What is the scheme for compassionate appointment? Do you have a scheme or not?
Scheme that 5% may be appointed.
Under what scheme? Where is the scheme? Why don't you bring it on record?
My lord, I will file the.
No, but why do you need to be told by the court when you already filed your affidavit? Your scheme is not on record. Why? What is the fun in keeping these documents enclosed?
Certain circular, my lord, that is already on record, my lord.
No. Is your scheme still valid or not?
Scheme is my lord, only the thing is that the petitioner government was working under the DLS system, my lord, that is direct labor system. Now that has been declared as dying cater, my lord, so our candidature for DLS cannot be considered. We have written to the headquarters.
Then you pay compensation. You pay compensation for it if you have withdrawn that scheme. Something to do.
That scheme has been withdrawn by the government of India, my lord.
Very well. When was it withdrawn?
In the year 2020, my lord.
And when did the accident happen?
Accident happened in the year 2012, my lord.
Then
My lord, there are other persons also who are above the.
we are not concerned. We are concerned with the petitioner's case.
To give according to the list, my lord. They are.
You have said since 2015, no appointment since 2015.
Yes, ma'am.
Then 2020, the scheme was withdrawn.
Scheme for the DLS, that DLS has been declared as a dying cater, so no appointment can be made under the DLS.
Who is your instructing officer? We want him in court with all records. Who is this gentleman, Mr. Arvind Kumar Pathak, who is filing it?
Now he has been transferred, my lord. Now the AGM is there, my lord.
Who is there?
Area general manager.
You should call the area general manager because you are unable to give us instructions date after date. I am sorry to say that. We have given you sufficient opportunities. You are merely deferring the matter on every date on one count or the other. You have not even had the courtesy to bring this scheme on record by way of an affidavit. You are an officer of the court, Mr. Singh.
My lord.
You are not under the rules of the FCI.
The only problem is that, my lord, from 2015, no appointment has been made. There is the difficulty, my lord. And then.
There is a difficulty created by you, Why have you not made appointments? You should have had some schemes in place.
That's, we are waiting for the.
You will-
headquarters, my lord.
we take the decision.
We have written on 8/8. Yesterday, again, we have written that about the consideration of the case of the, considering the case of the petitioner, my lord. Whether she can be inducted under the DPS, they direct payment.
Is the scheme on record, madam? Not on record. Then
Well, because the labor are not appointed directly, my lord. They are absorbed from the contract labor, my lord. There is the difficulty.
you have a scheme.
Scheme to give
Does the
whenever-
scheme exclude,
whenever such-
does the scheme exclude the laborers?
No, my lord.
Then-
Whenever the observation will be made from the labor, contract labor, then candidature or candidature will be considered. Since 2015, no labor has been appointed, my lord. FCI is working under the contract labor also, through contract labor also.
Now, who has prepared this list?
From the
Page number 13.
IRL division. my lord.
Yes, for what purpose? For appointment and compassionate? For what purpose?
For giving the appointment, my lord.
How will you give appointment if you're not?
That is the.
Huh?
Yes, that is the thing, my lord, from 2015. My instruction is that, my lord, whenever the appointment will be made, we for candidates will be. Considered, my lord.
You are a public authority.
Yes, you have.
You have extracted service from these people. You have given them some hope. And you are making their legal heirs and family members running from pillar to post without giving any clear indication.
After all, the petitioner son will work as a labor, my lord. On there is a contract labor, my lord. We can work there, we will absorb from there whenever the scheme will come, my lord. Whenever the application will be made, our candidature will be considered.
We are not interested in giving labor work or anything. This is for you to decide.
So that decision has not come
Who will take the decision?
from the headquarters.
From the headquarter, who's at the headquarter? Where have you stated that this decision will be taken at the headquarter?
I will raise. I will take your law.
Your committee has given a report that it is a case of death.
And you look to be the next 6 months, is it a case for dying in fungus manner?
Yes,
Your DR connection is your hospital
annexure 6
of my information.
their committee has given a report.
It is very important number, because it is their supplement. When it says that the person is invited to this office circular, number given for the 4/13/2003. Why do we instructions for compensation appointment?
You bring it on record, your statements, you bring it on record.
One week.
Whatever you want to bring it, you bring it in.
I could indicate further difference be given in the years of persons who died in harassment. That is why.
Yes, yes, Mr. D.K. Singh, learned counsel appearing for the FCI has not been able to furnish the precise instructions sought for by the court in respect of the claim of compassionate appointment prayed for by the respondents, by the petitioners. So, Mr. Singh submits that the scheme for compassionate appointment has, now what has been withdrawn, DLS?
DLS, my lord.
What is that DLS?
That has been annexed by the rate petitioner, my lord, I have paid. Act is 29, my lord. That is a circular number 1 of 2020 dated 8/1/2020.
The DLS has been withdrawn. DLS 29. What is that? Departmental Labor System
Labor system.
has been withdrawn by the FCI with effect from 2020. Therefore, the appointment or consideration for appointment under the compassionate scheme of the legal years of the petitioner has not been able to be proceeded with. So he however submits that the case of the petitioner will be considered for appointment in under the contract labor system through which the FCI is presently engaging laborers. So the said submissions, however, are not supported by any affidavit. Learned counsel is therefore permitted 2 weeks' time to obtain to file their affidavit and bring on record the specific scheme under which the case of the petitioner is likely to be considered. Is required. That apart, the scheme of compassionate appointment has not been brought on record. The same shall also be brought on record by the respondent authorities in their additional affidavit, by filing an additional affidavit. MSK Bhattacharya, Learned Counsel, appears to the petition. Matter stands referred till 1st of September.
One small correction, instead of contract labor, it is direct payment system, we have written to this headquarter also, whether our candidature may kind of
Direct payment system.
direct payment instead of contract labor.
Yes. Yes.
Not so much news will appear before you do some personal legal instruction. Not so, please, covered this regarding the similar matter of the 1914 of 2000.
Covered matter. We can dispose it of.
Yes, not so.
All right. Why did you apologize? I'm sorry, I didn't get you.
Not so, my senior could not appear before you, not so.
He was not there, you were there. You were there. No issue. It's hard, but the council disposed of it in terms of this order 1914. Yeah.
I hear that. Complex.
Item number 17.
Yes, Mr. Yes.
Where's the export date?
First, tell us what is the issue.
It's a very small list of India.
Secretary,
What is, this, very small, okay. First, it is 24/10/2018, where the petition.
you're referring to from the list of dates, yes,
The copy is the undertaking.
yes,
The first date is 24/10/2018, the petitioner was appointed as UDA. Next is Lordship 22/2019.
Hmm.
Lordship. 22/2019, the petitioner was directed to function as secretary to the MD AAC. On 15/5/21, since the petitioner was working as a direct MD to the secretary to the MD, the office wanted to regularize her post. That's why a circular was issued asking for options from the other UTs. This is important because the secretary report is a report which says contrary to it. 21/5, the 178 board meeting happened. 1/6, the petitioner was appointed. Thereafter, Lordship may go to the third page. 14/6, 15/6 is the date when the newspaper clipping of the incident that there was some irregularity in the 170. 16/6/21, Lordship may for a moment just take the affidavit in opposition for a moment. Affidavit in opposition of respondent number 2 and 3.
yes,
Lordship may go to page 103.
yes,
It's from the SS Mujumdar to Managing Director AICC. News subject is newspaper clipping dated 14 June published in Assamese Daily Loading.com. With the reference to the subject cited above, I am directed to enclose herewith a copy of the news article published in the Assamese Daily Loading.com on 15/6/21. 14/6, 15/6. Repeat as me under the heading such and such. In the above context, you are requested to submit a detailed report immediately against the news article published. Next page, Lordship, 104. This is the detailed report which was given by the MD on the same day, Lordship. And my part is page 105B. Page 105, Lordship. Regulation of post of secretary to the MD. The matter of appointment Ms. Anjana Borua as secretary to the managing director of ASCC was placed before the 178 BOD meeting, and after deliberation, the matter was approved. The appointment letter was issued accordingly. Lordship, pausing here, Lordship. Here, this report did not say any irregularity with respect to the appointment of the petitioner. Lordship, then page on the same day, page 102, Lordship, of the same affidavit. Same day,
102,
102
yes,
of the affidavit in opposition. Same day, it's 16 started off with the report is given on the same day, and the order comes. It has come to the notice of the government in transport department from the news report published in a section of media that some of the decisions taken in the 170th meeting of the board of directors ASTC held on 21/5/21 are inconsistent with the laid down procedures and rules. Report on the matter was called from the managing director, and after perusal of the report and the issued minutes of the board meeting, the decision taken in the 178th board meeting of the directors held on 21/5/21 has been hereby cancelled with immediate effect.
after perusal of which report?
This report, page 104. Now, Lordship, I have shown Lordship 104 pertaining to me. It is clearly, there is not a single whisper of any adverse. So what was the subject, what was the objective analysis done by the government to cancel my appointment as secretary to the MD? This happened. Thereafter, pursuant to this, Lordship may go to the LOD again. Lordship, pursuant to this, 17/6, I was removed from the post of secretary. Thereafter, what happened, Lordship? On 23/6/21, the secretary to the government writes to the principal secretary, transport department, to again asking for a report, again asking for a detailed report. 24/6, I was transferred to the ASCC room number. 29/6, now Lordship, 29/6, Mr. Yadav, Secretary to the government of Assam,
was appointed as the inquiry officer to inquire into the report. Now pausing here, Lordship, the board meeting in the board of directors meeting, Mr. Yadav Sekia was one of the members of the board. Lordship, the jurisprudence says that no man can be a judge in his own cause. He was a part of that board meeting and he has been made the inquiry officer. Be it as it is made, the inquiry report was finally submitted on 23/7/21. 23/7/21 report, Lordship is if Lordship picks up that report, that is at page 138. Type copy. This is the meeting. Lordship, may I read the report?
No,
A relevant
es-
portion.
essentially, there was some difference of opinion which according to Mr. Soikia was raised and it was not recorded. And then
This is the version of Mr. Soiki.
Mr. Soikia.
And Mr. Soiki has not put forth anything on record that this is the dissent letter of other board members.
No,
How can he?
No, he said during the meeting, there was a proposal, there was some dissent, which was not.
Lordship may come to the conclusion, Lordship.
Yes.
Before the conclusion of page 140, what was the report pertaining to the petitioner? It is in page 140. As regard point 2, regarding out of turn promotion of one employee of AICC as secretary trade.
2.2, you come to 2.2.
2.2. As per agenda number 11 titled regulation of post of secretary to MD. In the 178 board meeting, a proposal was placed seeking approval to appoint Srimati Angana Borua and UD of AICC as permanent secretary to the MD board of AICC. Proposal was also placed to exonerate the requirement of the sovereign stenography for the post of secretary in respect of this UD. Extract of the said agenda is enclosed here. No dispute to that point. During discussing, myself and few others raised question as to why such out of turn benefit is proposed for a specific employee, and the MD stated that she has been looking after the works of secretary for over 2 years. Postgraduate in English, knows computer of the IT handling, and her performance was outstanding. Question was posed, answer was given. This is reflected in the board of directors meeting. After deliberation, members did not agree for exoneration of the requirements of shorthand stenography, but opined that she may be allowed to officiate as secretary as existing pay structure with additional financial benefit of 370 per day as proposed. Now, this is did not agree. This is not reflected in the board of directors meeting. This is his version. If he had dissented, okay, if some other inquiry officer would have been there, his dissent would have been there. What about the other? From where he has got this knowledge? Did he inquire with the other board members?
He was present.
He was present,
Hmm.
but he was present.
He was
other than-
present, he said so and so did not
But
agree.
it is contrary to the point of judging his own cause.
No, there's no judging his own cause. He's been asked to give a report, he's given a report. Your question is whether this report is sufficient to be accepted.
I'm.
Yes.
But in the circulated meetings, the board decision was found incorrectly placed as per board approval towards exoneration of requirement for promotion and other promotional decision except additional daily allowance. Extract of the circular minus against agenda 11 is included.
No, so your prayer in the petition is what? To sustain the board decision,
Yes,
to appoint you.
yes.
The
Logic,
board has decided to recall that decision.
no, it has an order of the, it's by order of the government. Board has not given this. It is the order of the government which has.
Where is that order?
Page 102.
102.
And
Board, the government has deep and pervasive control over the board,
Lordship,
over the corporation.
yes, Lordship. Had there been in the report of the deed and MD pertaining to the fact that my appointment, there was irregularity, there was no approval, then Lordship did. Now this order is prior to this report.
No, quite right.
Lordship may, just for
But
a moment,
after this report, what happened?
Lordship, there is nothing to happen because ultimately I was already reported to the post.
Who was the MD?
MD was when he was.
Who got transferred subsequently?
Yes. You were him. Lordship, please fill page 141 because the report conclusion is important. What is the basis of the report that they have come? They said there are 2 points. One point is that.
No, first thing is, do you have a right against an order passed by the board. Whereby your basic requirements or requirements of eligibility have been modified by the board or.
It is not modified by the board. Lordship, the order says the government has done it based on a report which the
No. Your requirement is shorthand and something.
Lordship.
So the board decided that we are doing away with the shorthand, we will do you'll pursue your training, etc.
Lordship.
Now the question is whether the board is competent to do it.
Lordship, they have been a practice in ASCC where there are other persons who do not have shorthand and they are working agents. And I have stated in my petition.
Yes, and what is the stand of the government?
This
Who is for the board? Not board, what is the corporate? Corporation.
I am appearing for the corporation.
Hmm.
Lordship, in our affidavit, Lordship, paragraph number 5, may I read? Lordship?
No, your question is that earlier resolution has been suspended or withdrawn or whatever by the government.
As per the last court order, your Lordship has queried under what provision,
Hmm.
he has been promoted
Hmm.
for this post, whether any provision is there or not.
Hmm.
Lordship, while promoting the petitioner to that particular post, no service rule was applied by the then MD. Lordship, ASCC follows Assam Directorate Establishment Ministerial Service Rules 1973. Lordship.
Hmm.
Lordship, the petitioner was appointed as this one, Lordship. You may have paragraph 10 of our affidavit, Lordship.
Hmm.
May I read, Lordship?
What is your affidavit?
Paragraph 10 of our affidavit.
Paragraph 10. All right.
File on 7/4/22.
Okay.
Lordship. That we trigger, may I read, Lordship? That with regards to the statements made in paragraph 13 of the writ petition, the deponent denies the statements made therein and reiterates and reaffirms the statements made in the proceeding paragraph of this affidavit in opposition. Further, as per proportional list of all the posts of ASCC under different cadres in compliance to government norm, post of the petitioner, that is upper division assistant, as appointed by ASCC authority, is a grade 3 post under the category of ministerial staff HO, and the secretary to MD is a grade 2 post under the same category. In between both the posts, there are two more. Post office superintendent grade 2 and superintendent of accounts grade 2. Initially, writ petitioner should have been promoted to this post before promoted to the post of secretary to MD. Moreover, the writ petitioner appointed to the post of UDA only in the year 2018, and within such short span and short experience of not holding a post even for a minimum of 3 years, and also not having the actual eligibility to the post of secretary to the MD, the writ petitioner is not in a position to claim the same post of secretary to MD. Notice that we have annexed one list also, hierarchy position list logic. Annex 9 logic. If logic comes to serial number 37. Yes, Lordship.
Upper division.
Yeah, Lordship, earlier the petitioner was appointed in that earlier serial number 37. Then immediately he was being promoted to serial number 26, that is secretary to MD, from grade 3 to grade 2. Long jump, Lordship.
No. In grade
3. She was initially appointed as grade 3, which the petitioner himself herself has admitted, Lordship. Later on, she was being jumped to grade 2 post without following any due procedure of it.
But under what provision are you saying that from 37,
Lordship,
the promotion to
this is the
26?
hierarchy of, this is the restructure of ASCC officers and staff resolved.
But there must be some set of rules, notification. Where is that?
Lordship, rule is
That feeder category post is this, that promotion is this, promotion to such post is necessary. On what basis are you saying it?
Lordship,
See, come to page 32,
Lordship, we have
page 15, annexure 9.
Lordship,
Annexure 9, 37 is grade 3. Right, 37 is grade 3. then you say next post is office superintendent.
Office superintendent,
That is grade 2.
grade 2.
Now, if there is grade 2, then this grade 2 starts from 35 to 25.
Yes, Lordship.
So you must have a set of rules which says that the feeder category to 35,
35 to 26, Lordship.
uh,
35 to 26.
35 to 26, 25, 25,
25, sorry.
35 to 25, let us say from 35
Mhm.
or to the post of 35. The upper division
Hmm.
is the feeder category. There must be something like that. Or to the post of 34, the feeder category is 35. To the post of 33, feeder category is 34 or 35 or both. Where is that provision? Otherwise, 37 is grade 3.
Lordship,
Next promotion is in grade 2.
Lordship,
It can be in 35, it can be in 25, it can be in 28. They're all grade 2.
Lordship, Lordship.
So where is the justification to submit that from 35, from 37, you must come gradually upwards?
Lordship, this is the Assam Road, State Road Transport Corporation Employee Service Regulations 1971. Lordship. Lordship, in the last page, Lordship,
Is it available here?
Lordship, I can produce this one, Lordship. I have.
See, this is the problem. You are not producing the rules. You should produce it along with your affidavit if required. You are relying on this.
Lordship. Then Lordship.
These are not judgments. These are not judgments that you are relying on. You know,
Lordship, then Lordship may kindly give me some time so that I can bring it on record additional affidavit by way of additional affidavit, Lordship.
you decide what you want to bring it and bring it at once.
Lordship, Lordship, Lordship.
Because once the hearing is opened up, we want to proceed with the hearing, you come up that this document is not there, that document is not there. Why is this happening?
Lordship.
If you are not ready, if you think this is necessary, you should have prayed for time before the matter was opened up. Don't take a chance. If you want to, if you are ready for hearing, say you are ready for hearing. Whatever documents you need, you bring it on record.
Lordship, I will.
What does the rule say? Does it define any cater strength, feeder category?
Lordship, this is the hierarchy position is defined.
Let us see
Lordship,
page number.
from 34 to 35. Lordship. This is only the payment and hierarchy is.
30.
Lordship, last page 34 and 35. This is the payment, Lordship. Hierarchy list.
Now we are in grade 3.
Lordship.
So grade 3, there is no post of secretary.
No.
Then,
No post of secretary, Lordship.
Yeah.
Grade 2 is the secretary.
no, what is that post? UDA. What is the post in she is
She
working?
was initially appointed as UDA. In the
Where is that post? Where is that post?
Lordship, it's there. Main. The
Grade 2 or grade 3?
Grade 3, Lordship.
Grade 3, we don't find any UDA.
Main.
Mechanic, driver, staff, conductor. UDA is shown as grade 2 ministerial officers.
Lordship.
Your rules. And ASTC is in such a pathetic condition that you come with only one set of copy.
Financially constrained.
Therefore, we are giving you the digital mode.
Lordship.
Make use of the digital mode.
Lordship.
Why you send an email, we'll take printouts. We are not interested in depleting ASTC's finances. Take so. Last page, you see. Last page,
Lordship.
you'll find grade 2
Grade 2.
is already grade 2. So therefore, we close this matter. We direct the matter to be heard by the, who is the authority here?
This is the matter of last week, my lord. Honorable court has directed the board of right to take, reconsider their cases because 178 board meeting has been, decision.
Then why are you sitting silently? Why don't you give us a copy?
That's my,
Will you given to whom?
no, this order is yet to be uploaded.
Who will take that decision? Board or the?
Board. Board is the supreme authority, my lord.
Very well, then we decide, then we close this matter.
My lord. Board will take a call.
Huh?
The,
No. They will take a decision.
Lordship,
If they take a decision in your favor, the earlier order will be recalled. Your claim is that you are appointed in some board meeting, that board meeting has approved. You have not been able to show that your promotion that you are seeking is as per the rules. This is not your case.
No, Lordship, it cannot be my case because the board itself says that I will, so that way.
You are an employee of the board. You are expected to be familiar with the service rules.
Lordship, no,
You point out to making reference to the service rules to tell us that your promotion which was considered is absolutely as per the rules.
Lordship, that is not there because I could not have been promoted as the secretary. It was in a special circumstances, the board took that meeting. This was my case.
Mr. Counsel, we know that astute counsels find it difficult to give a direct reply. We know that. So we are raising a question that it is not your clear case that in terms of the established rules, your case was considered correctly by the board. You were promoted. However, only because of some news item, the authority had kept the order suspended. This is not your case. Your case is board had considered, therefore it is to be presumed it has considered, but the board resolution is very clear. Your essential recruitment qualifications have been
Exonerated. By the DLM.
have not been enforced. Maybe the board has the power to do so, maybe it doesn't have the power to do so. So all these things will require examination by the board in vis-a-vis the service rules.
Fresh board meeting is.
We don't know. They hold
Subsequent board meeting is met.
heard learned counsels of the parties, this writ petition is filed with the petitioner agreed by the order dated, where is the order 103?
Lordship, order dated, which order?
You're challenging which order?
I am challenging the order dated 16/6, 17/6 and
103.
21.
Order dated 16/6/2021, issued by the Deputy Secretary, Transport Department, Government of Assam.
76 is managing director.
No, 16/6 order is also of the chair.
As well as. Where is that report?
Report is page 138, 23/7/21. Though I have not made a trail, so that report was not furnished with me.
We have managed in our affidavit also.
You do one thing, let's file this petition with the following praise, 1, 2, 3. But the petitioner was working as what? UDA. And posted. And was working as a UDA in the respondent corporation. And she was allowed to work.
Appointed was.
No, initially you were working.
Initially, I was working as UDA, I was appointed as secretary to the MP.
Before that, you did not work. No, before that, did you work as a secretary? Were you allowed to work as a secretary?
Yes.
That is what we are saying.
I'm excused.
Was allowed to work as the secretary to the MD ASTC. Stop. In a vacancy which arose because of the leader incumbent, the retirement superannuation of leader incumbent. The petitioner's case was considered and the board of ASTC in its meeting 178th board meeting held on 21/5/2021 approved the appointment of the petitioner as the secretary to the MD. Stop. Subsequently, because of a news item, the same board meeting decided on certain other issues, including the question of the appointment of the petitioner as the secretary. So subsequently, a news item appeared in one of the local newspapers, raising a controversy with regard to the decisions taken by the ASTC board in its board meeting, in its 178th board meeting held. Stop. The transport department, which is the concerned department of the government under which has supervisory powers over the corporation, directed the MD to, where is that order again? 103. 103. Directed the MD to submit a detailed report in respect of the allegations raised in the newspaper item. Stop. Pursuant thereto, on 16/6, is it 16/6 or 16/7?
16/6, my lord.
16/6/2021, the report was submitted by the managing director. Stop. Then 102. 102. However, prior to calling for the report, the secretary to the government of Assam cancelled the decisions taken in the 178th meeting of the board of directors held on 21/5/2021. Stop. Well, being agreed, the present writ petition has been filed. Stop. The learned counsel for the petitioner submits that there was no infirmity in the qualifications of the petitioner, and the board had appreciated her the services rendered, and on the consideration of the services rendered, the board had taken a decision to appoint the petitioner as the secretary. Stop. Where is the board resolution?
Page pertaining to her is page 35 of my petition.
Item number 11.
Insofar as the petitioner is concerned, the resolution adopted by the board is extracted as under page 35, item number 11. In view of the discussions held by the board, the appointment of the petitioner to the post of secretary to the MD was approved.
Page 46.
Thereafter, the petitioner was appointed as the secretary to the MD by the order dated 1/6/2020. 1/6/2021. Stop. Pursuant to her appointment, she had been working, rendering her service as the secretary to the MD. Stop. Learned counsel for the petitioner submits that where the ASTC is a body corporate established under the State Transport Corporations Act,
Road Transport.
Road Transport Corporations Act,
1950.
1950. 50 or 59?
50, Manoj.
50. Stop. The Transport Corporation has been given the power to make necessary rules and regulations in respect of the employees engaged by the corporation. So it is submitted that as on date, the Assam District Ministerial Services rules 1973 is the rule which is adopted by the corporation or which is applied by the corporation in respect of promotion and recruitment and governing the service conditions of the employees of the petition, employees of the corporation. Stop. Learned counsel for the petitioner submits that the board being a body corporate and is the corporation being a body corporate and all policy decisions being adopted by the board established under law. For one, once a decision is approved by the board without proper reasons and justification, the cancellation of the board decision ought not to have been done by the government. This cancellation was done by the same person who gave a report. Huh?
Report is submitted to MD, Manoj.
103, 102. 102, who is the
Secretary to the government.
he is not the person who gave the report.
No, cancellation was done by. No, he is the same person who gave the report.
What are you saying, Mr. Counsel?
He is the same person who gave the report.
Are you sure?
Yes, Lordship. According to JSK.
Or you suddenly decided to be sure?
No, I've just.
Order. It is submitted by the learned counsel for the petitioner that in respect of the 178th meeting of the Board of Directors, which was held on 21/05/2021, the claim was issued on the basis of a report which was stated to be furnished, which was submitted by, where is the report? Which report?
Lordship, we have
That report is 104 report.
138.
Lordship, that report was not considered by this person, because that was after the order was passed. Order was passed on 16/6.
Who submitted this report?
He submitted Jerome Chindia, 138.
He is the same person who issued the cancellation order.
Manoj.
This report was submitted by the what is the what? The secretary,
Secretary.
the government of Assam, the Department of Transport by report dated 23 July 2021. In the state report, it was in respect of the promotion relating to the petitioner. It was stated that his promotion was given out of turn without following the proper procedure as well as the rules prescribed. Stop. It was further stated that that the person who could do that the officer who submitted the report was also a member of the Board of Directors and was present during the 178th meeting of the board. And during the discussion, certain objections were raised by the state officer along with other members of the board. And accordingly, the board had decided to proceed with the appointment of the petitioner, but without exoneration of the requirements for shorthand / stenography. But permitted her to acquire the qualification within a fixed period of time, within 4 months. Now, what is the within a fixed period of time? So the report reflected that although these objections were raised during the meeting, subsequently, when the minutes were circulated, these meetings were these objections raised by the state officer as well as other members were not reflected in the minutes circulated. So the report of the secretary was submitted pursuant to the orders dated 29 June 2021, issued by the Principal Secretary, Government of Assam, who was appointed as an inquiry officer to inquire into the allegations, alleged irregularities and inconsistencies regarding the decisions taken in the 178th meeting of the Board of Directors. So learned counsel appearing for the respondents submits that the petitioner is a grade 3 employee and is working as an upper division assistant. She was given out of turn promotion to the post of secretary to the MD, which is a grade 2 post. So referring to the what is this list? The restructuring list whereby the posts and offices under the ASTC was restructured, which is available at Annexure 2 of some additional affidavit.
Both the respondents have filed this. Annexure, page 1, annexure 9, as well as annexure page 115.
Which is annexure 2 of the affidavit in opposition filed by the Department of Transport.
Yes, respondent one.
Yes, we have.
That there was no infirmity in the order passed by the Secretary, Department of Transport, cancelling the 178th resolution of the board. So it is submitted that for the petitioner working as an upper division assistant to be promoted to the post of secretary MD, which is in grade 2. There are several posts in between to which the petitioner is required to be promoted to stop. There are as many as how many? 1, 2, 3, 4, 5, 6, 7, 8, 9. There are as many as 9 posts which have been superseded by the petitioner.
It's, I think they are saying that from the UDA, he needs to be, she needs to be promoted as superintendent in the post of superintendent of accounts and then secretary. That's what I've been looking at the affidavit.
Is it?
What if we produce the affidavit page 2?
Page number?
Page 131 maybe. Same, both the have said which page.
It is submitted that the petitioner is required to be promoted to 2 other posts in between, namely superintendent and superintendent of accounts, before being promoted to the post of secretary MD. Stop. The board resolution does not reflect any decision of the board in respect of the supervision given to the petitioner. As such, there is no infirmity in the orders cancelling the board resolution. And the petitioner will be given promotion to the available vacancies as per the rules and as and when she is qualified. Stop. Learned counsels for the parties have been heard. Pleadings have been carefully perused. It is seen that the board had taken a decision after due deliberations. So nevertheless, the board being a body corporate established under the State Corporations Act, Road Transport Corporations Act 1959, 50. It is in terms of the provisions of the Act, the government has deep and pervasive control over the corporation. Stop. The decision of the government in respect of any policy decision taken by the board cannot be restricted, cannot be held to be without any powers in view of the provisions of the Act. Stop. The learned counsels for the parties or the pleadings available in court does not reflect the proper service regulations or rules that may have been resorted to by the authorities of the ASTC, which govern the service conditions of employees, including the petitioner. Stop. From the affidavit filed by the Department of Transport, although it is stated that there are two posts in between, namely what are the posts? Superintendent and
Superintendent of Accounts.
Superintendent of Accounts and Office Superintendent. In between. Before the petitioner can be promoted to the Secretary of MD, is not supported by any rules or regulations or notifications or OMs. Stop. That apart, it is evident from the pleadings that the secretary who had submitted the report at the relevant point in time a report dated 23/7/2021 pursuant to the order of the department dated 29/6/2021 is the same officer who was also a member of the board 178 board of meeting. 178 board meeting. Stop. That apart, the impugned order at dated 16/6/2021, whereby the order dated whereby the decision of the Board of Directors in its 178th meeting held on 31/5/2021 was cancelled with immediate effect, was also issued by the same officer. Stop. Prima facie, it appears that one officer who was a member of the Board of Directors was appointed as the inquiry officer, who was the Board of Directors and who had taken a decision as per the minutes, approving the appointment of the petitioner to the post of secretary to the MD in the board's 178th meeting held on 21/05/2021, was also appointed as the inquiry officer by the government by the order dated
29/6/21.
29/6/2021. And He is the same officer who ultimately submitted the report, raising, doubting the procedure adopted by the board in its meeting held on 21/05/2021. Insofar as the petitioner is concerned, petitioner's appointment is concerned. So, under such circumstances, it is evident that one officer who was a member of the board, which took a decision on 21/5/2021, was also the inquiry officer and was also the officer who had ultimately passed the orders cancelling the board decision. Stop. Such action by an officer of the state government cannot be countenanced in the face of, cannot be accepted to be proper, as the same is in conflict with the established rules of natural justice. Stop. The officer who was a member of the board of directors, who had approved the decision of the appointment of the petitioner, conducted the inquiry, submitted the report, and also passed the order suspending the state board of suspending the order dated 21/05/2021 of the 178th meeting of the board, in which he himself was a member, cannot be accepted to be correct procedure. So, in that view of the matter, this court is of the considered opinion that the impugned order dated 16th June 2021 cannot be allowed to stand. Stop. However, cannot be allowed to stand. The same is therefore interfered with and set aside. Stop. However, considering the fact that there is some cloud with regard to the procedures established under the board, under the corporation, or adopted by the corporation, or prescribed by the transport department in respect of any rules or OMs governing the service conditions, the matter stands remanded to the, will take a decision. Board of Directors, ASTC. The Board of Directors, ASTC, will take a fresh decision insofar as the what about the other issues? Other issues are not here. So far as the claim of the petitioner, so far as the decision which was taken by the board in 178th meeting of the board on so and so date in respect of the appointment, promotion of the writ petition. So, the order is set aside to the extent it relates to the petition. The board will reconsider this matter upon taking all attending facts and circumstances and the rules, regulations / OM / notifications in respect of any service conditions governing the laying down the criteria governing the service conditions of employees like the petitioner. Stop. The board will permit the petitioner to submit any documents or credentials if required. And thereupon the board will take a reasoned decision. We'll take a decision and pass a reasoned order in respect of the claims of the petitioners raised. Any such order that is passed, a copy thereof shall be served upon the petitioners. So this entire exercise will be completed by the board of directors within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition is accordingly disposed of in terms of the above. No order is to post. Yes,
My lord, may directed that number 283 to place the matter before the board of directors.
respondent number 2 and 3 are directed to place the matter for a first decision before the board
My lord,
constituted under the ASTC.
lordship, diplomat.
The matter be placed by the respondents 2 and 3 within 10 days from the date of receipt of the certified copy of the order, and thereafter board will take a decision within a further 60 days.
My lord.
Please, your pleasure.
Lordship, I am agreeing for example number 1.
Please take down the names.
My lord.
You fill up your. Yes,
Lordship,
yes.
amendment.
Anything you want to submit?
Item number 21.
Yes, it is. So the application under section 11 of the Arbitration Act. So required procedure is the same is under review by expert committee formed by the central government. Madam. And the same is also subject matter before the constitutional bench of the apex court. Madam. My place the judgment. Madam.
What is the issue here?
Madam, appointment of arbitrator.
Ah.
Section 11.
Then,
Madam, the general manager did not appoint after the representation by us, by the petitioner. Madam. So then, madam, we are appealing the honorable court under section 11 of the Arbitration Act. But madam, the provisions are already under review by expert committee. Madam. The same is pending before the Supreme Court. And the court bench of this court has already deferred the matter to the arbitration.
all right, show us. Yes, madam.
Otherwise, Lordship, I have filed my affidavit and our case is that his claims are more than 20%. That is.
So it's a question of appointment.
Lordship.
Why have you not appointed? Your point.
The case could judgment, madam. First para in the last page. Detail page 4. Madam, may I read?
Yes.
Madam, Mr. R. Swinton, Learned Attorney General for India, submits that on 14 June, the Union Government has constituted an expert committee to consider the provisions of Arbitration Constitution Act 1996. Madam, para number 4, hence presently we direct the hearing of these two references to the constitutional bench be referred by a period of 2 months.
What are the references?
Madam, it was, madam, this case, the present case, madam, it was referred by a 3 judges bench to the constitutional bench regarding the validity of the finding of the Supreme Court, madam. It was referred to the apex court, sorry, the constitutional bench. Madam. So when this matter came up before the hearing before the constitutional bench,
What was referred? What is the issue?
my lord, I.
A judgment to like some. 2020. That's not too low.
Well, the basic issue involved in the instant matter is whether the appointment of arbitrator was in conformity with the law laid down by this court in TRS Limited versus Energo Engineering Projects Limited. The next page. Para 3, madam. It has been brought to our notice that subsequently a bench of 3 judges bench in Union of India versus Toronto, while its order dated 11/1/2021 prima facie expressed its disagreement with the view taken in the present case, madam, which I have referred. Central Audience for Railway Electrification Supra requested the Honorable Chief Justice to constitute larger bench to look into the correctness of the decision in Central Organization. In the present case, after the appointment of arbitrator nominated by the respondent hearing, which is matter Southern Railway, in the present case, the proceeding took place before the award was passed on 30/3/2022. Madam, the next page, madam. Madam, the award was said, the award passed by the arbitrator appointed by the Railways, madam. Para number 9. Then,
Yes, what was the direction in this matter?
madam, this, the arbitrators were appointed by the South Western Railway, madam, as in this case is not Central Railway, madam, NFR. So, madam, the same is pending adjudication before the.
You check up and tell us, madam. You check up and tell, what, do you agree with this submission?
Lordship,
You check up, there is some question regarding appointment of arbitrator, which is pending.
Madam, the arbitral award was itself stated in this order.
No, that's all right, but the reference before the full, the constitutional benches with regard to The appointment.
Provisions of the Arbitration Act.
Lordship, our case is that what is his claim, Lordship, that is Lordship.
Please understand these orders. We check up whether what is the reference made before the apex court. It is submitted by the learned counsel for the petitioner that the references in respect of what the appointment of arbitrators,
The provisions of Arbitration Act.
provisions of arbitration act are presently pending discussion before the constitutional bench of the Supreme Court. Under such circumstances, the learned counsels are subject that the matter be deferred till the decision of the constitutional bench. MS P. Sharma, counsel appearing for the railways, submits that she will complete her instructions in respect of the references pending in the Supreme Court and apprise the court on the next list after 3 weeks.
Madam, after the 12 September, madam, the date is between the apex court. Madam.
We will adjourn it after 12 September if required.
Madam,
You have not been able to tell us the references. What is the reference?
with regard to the provisions of the arbitration.
Does it mean that no arbitration proceeding will take place now?
No, madam,
That is what you are submitting. When the act itself is under reconsideration,
madam.
everything must be stayed.
Madam, the arbitral award passed by the arbitrators appointed by the regulator has already been stated, madam. That
Correct, but your submission is that there is a reference pending which has got, which will have bearing in the proceedings.
madam.
So what is the reference? You place it before the court on the next day.
Alright.
Now,
Item 22.
yes,
Lordship, petitioner was appointed as medical record technician, Lordship, in 1999, Lordship. His service has been regularized, Lordship, in page number 24, Lordship, 27/10/2010, Lordship. Presently, Lordship is medical record officer, Lordship, as inside, Lordship.
you are asking for promotion.
Promotion, Lordship.
Then what is wrong with it? Why have you not been given?
Lordship, may I have a look at page 47, Lordship, the affidavit of the superintendent, Lordship, at page, at para 3, Lordship. Page 47, flag marks 3.
47,
Yes, sir. Page 47, para 3.
yes,
May I read, Lordship?
yes.
That the entering deponent text to state that the instant reputation has been instituted by the reputationer for promoting him to the post of medical record officer, in which that instant reputationer is holding as in charge. If necessary by holding state PTC and not to appoint anyone directly through the advertisement dated 6/4/2022 published by the memo number so and so to the same post. In view of the above, it is respectfully submitted that the eligibility criteria qualification for the post of medical record officer is graduate in arts, science, or commerce from a government recognized board or university, along with medical record training from a recognized institute. Shri Subhash Das, the petitioner here is a graduate but not having the medical record officer training. Further, he is not even a MRT trained from a recognized institution. It is relevant to mention here that the Central Bureau of Health Intelligence, CBHI.
What is the name of the person?
Subhash Das.
Subhash Das. He is not from a recognized institution.
Lordship, he is not having the
Training.
qualification, Lordship, training, which is required for having, for holding the post of medical record officer, Lordship. In fact, he does not even have the medical record trainer. Lordship, page number 26, Lordship, same superintendent, Lordship. May I read, Lord? May I read? With due respect, I am furnishing here with the required information related to permission of Mr. Subhash Das MRT against the vacant post due to retirement of Sri Yogeshwar Talukdar MRO Center, and Sri Subhash Das is the senior most among the all candidates, Lordship. Lordship, kindly from Lordship, page number 28, Lordship. Lordship. May I read, Lordship? The page number 20, Lordship. which reference
You are in which post now?
is in charge MRO.
MRO.
Lordship, but we have advertised for and
Hmm.
which reference to the letter on the subject, I had the honor to inform you that the superintendent GMCH has forwarded a prayer petition in respect of Sri Subhash Das petitioner Lordship, senior most medical record technician for promotion to the vacant post of MRO at MRD GMCH. Lordship, it may be mentioned that the MRO is a promotional post, Lordship. The director said, Lordship. And once promoted, Lordship, once promoted, an incumbent needs to undergo training for a period of 1 year. MRO course in view of the above, it is requested to accord necessary approval to Deputy Subhash Das, MRT GMCH for higher training at Saptatam Hospital MRT Department Training Center, New Delhi. Once promoted, Lordship, after promotion, it is a rule circuit, after promotion, the person has been sent to the.
No, but he says that your basic requirement is not. You're not a graduate.
He's just.
No, sorry, he's a graduate,
Graduate, Lordship.
but not medical officer trained.
And Lordship.
What is MRO?
Medical record officer.
Medical?
Record officer. And MRT is medical record technician.
So what is the requirement for the present post which is held holding?
He should be a graduate and having the Lordship degree and having that Lordship medical record officer training, Lordship. Lordship, the situation is this, Lordship, if your Lordship comes back to the 47 page, Lordship, at para 3, Lordship,
Hmm.
the last paragraph.
No, let us see what is his qualification. He is a graduate, and then
There are nothing, Lordship. There is
no training.
no training for the medical record technician, Lordship. So right now we cannot even.
So where is the requirement of MRT training?
At page 39, Lordship,
39.
the affidavit filed by the DAM, Lordship.
Why don't you refer to the rules if you have any?
Sorry, Lordship, page is 39, Lordship.
39.
Yes, Lordship.
What is that MRT?
He is MRO.
No, he is now in what post? MRO.
MRO in charge.
To be in charge, he must be in some post earlier,
MRT.
MRT.
Yes.
So he's a medical record technician. HSLC, bio, computer. Preference to be given,
Yes,
that's all. It's not mandatory.
but now Lordship is claiming the post.
He is claiming the post of MRO.
Yes, for this he needs to be a graduate, science, arts, commerce from a recognized board or university.
He is a graduate
Lordship.
with MRO training from recognized, but MRO training will be conducted by your officer only upon his appointment.
No.
That is what the letter says.
Page number 28, Lordship. May I read that paragraph, Lordship, at page 47, Lordship, it is very clear, Lordship. The
No, before 47 come to 28. This is by the DME. This is by the DME.
Yes, yes.
He will need to undergo the training for 1 year.
6 months,
Once promoted,
once promoted.
once promoted. This is by the DME. And who has filed the affidavit?
With the
Superintendent.
at page 47, that is Jamie is the appropriate person.
Huh?
Jamie is the appropriate person. Lordship, if required, Lordship, is there a particular point, Lordship, I will get the specific instruction.
Once your affidavit is filed, where is the scope for instructions?
Lordship, in the affidavit, we have not.
Affidavit you have stated by holding phrase not to appoint.
From 2020, Lordship, I am in charge of Lordship, DM's affidavit at page 38, Lordship, para 3, Lordship.
Let us read your affidavit at 47.
Yes, Lordship. 47 last para, Lordship. It is relevant to mention herein that the Central Bureau of Health Intelligence, CPHI, conducts the in-service training course for 1 year.
Not that, before that.
In view of the above, Lordship.
Hmm.
In view of the above, it is respectfully submitted that the.
Where is the memo? Where is the memo? There is some advertisement. Where is that?
Yes,
advertisement?
yes. That is at page 36.
36.
35. 35, Lordship. Serial number 23.
This is for medical record.
Officer, 23, serial number.
This is for fresh. When is this advertisement issued?
Because lordship, we are not having suitable candidates, lordship, to hold that post. And lordship, this is for the betterment of the public, lordship. We need better candidates.
What is the requirement of the MRO? Sorry, MRO, yes.
Graduate, lordship, serial number 12 of that.
So come again. He is now MRT.
He is MRT. but
He wants a promotion to MRO,
But he,
but you want a direct recruit.
yes, lordship. For better candidate, lordship, because he is not having the, that has been said, lordship, at serial number 12 of the same advertisement, page 35, serial number 12.
Hmm.
Medical record on the right hand side, medical record officer,
Hmm.
graduate in arts, science, commerce from recognized board or university with medical record officer training from recognized institute. He's not having that.
But this is for direct recruitment.
Yes, no.
He has to be promoted.
All my PDCs are lordship. Lordship, may I read that whole para lordship, 47 lordship.
Does he have medical record technician training?
No, lordship, and that's why he cannot now do this
So
training.
if he's no, then why are you kidding him? Why don't you terminate his services?
Lordship, in case number 24, lordship, I started reading lordship, but lordship, that we can do, lordship. But lordship, to that specific point, lordship, whether he has to take the training.
Where are your rules? If you have any OM rules, guidelines,
That was one thing.
what is your response to the letter of the DME?
Lordship, it is very silent regarding that.
Then it is admitted. You are showing us qualifications for direct recruits.
But lordship, even if he is promoted, lordship, then also he is required to have the.
Exactly, you have to send him for training.
But he cannot do that, lordship. He is not having the MRT training. May I read the entire paragraph, page 47, lordship,
Hmm.
para 3.
So how is he supposed to acquire the MRT training? Yes,
Lordship, from the last para or?
wherever you want to read.
It is relevant to mention here is that the Central Bureau of Health Intelligence (CPHI) conducts the in-service training course of 1 year, course from medical record officer MRO at Safdarganj Hospital, New Delhi.
Are you MRT trained?
Lordship, no, not trained, Lordship.
MRT.
MRT, Lordship, in page number 24, Lordship. My service has been regularized as MRT, Lordship.
Without a training.
Lordship, how they regularize my service? Page number
We direct them to deregularize.
Page number, if the wrong order was said earlier, Lordship, then how do you rectify it? Page number 24, Lordship.
You're regularized, quite right, but do you have the training or not?
Lordship, I am in the self-pay lordship, I am no itself, lordship, I am as MRT.
Then we are dismissing your petition.
As MRT, lordship, I will know, lordship, I have no itself, lordship, I have to.
There is nothing there. You see your representation at page 25.
Lordship, page number 24, lordship, as MRT, lordship, my service has been regular.
Correct, but kindly see page 25. Page 25, you say that you were serving as MRT. Now 1, 2, 3, 4, come to the second last paragraph.
Lordship,
During the period as MRT,
sir, that's being a graduate and present senior most MRT.
no, below that.
That's during the period of as MRT in my service, I have gathered sufficient experience in
Correct,
various.
but no training,
Function,
no training,
medical record department as well as lordship.
no training. How will anybody assess your performance, your requirements? How?
Lordship,
On what basis?
lordship, lordship, how did this lordship regularize my service, lordship?
Then we direct them to look into it.
Yes, lordship.
If you are doubting the fact, the regularization of service is with regard to the post.
Lordship. My service is regularized, so
Now, for the next promotion, you must have the qualification.
2010, lordship, my
You are asking for promotion.
lordship.
So if the promotion is if you are eligible for promotion, if you have the MRT training, then we can direct consider for promotion,
Lordship, for MRO lordship, there is no,
not MRO, MRT.
lordship, there is no rules of training lordship for MRT lordship.
We are referring to some affidavit.
Lordship. There is no rule lordship. There is no rule lordship.
What is the post of MRT? What kind of training is necessary? Nothing is there.
Lordship regarding MRT lordship. Lordship may come to 48 page. Last paragraph, second last lordship. It is also relevant to mention here that medical record department was being run without any qualified medical record officer MRO. But in order to improve and strengthen the medical record department of the hospital and the advertisement.
You consider is, you file a representation, let your representation be answered.
Yes,
Who will consider it?
lordship is the DME.
The DME.
Response number 3.
DME has already answered in his favor.
Lordship, lordship.
DME has already stated that he should be sent. What no? Page 28.
Lordship, that was considered, but if I read that apart, in case of the petitioner, it was found that the petitioner was initially recruited in the grade.
He is employed under whom? Under whom?
The,
Superintendent.
yes, yes.
Then why the DME?
He is the director of medical education.
We know he is the director of medical education.
Superior.
He is not in the education system. He is in the he is in the hospital.
Yes, superintendent. Respondent number 4, under DME. Let him file a representation before the.
I heard learned counsel for the petitioner, for the parties. His writ petition has been filed with the petitioner, who is employed presently as a regular. What is that? Medical
Record technician.
record technician within bracket MRT. The petitioner was appointed as what?
Initially, lordship, initially is get 4 lordship.
Grade 4,
18-1 to 1999.
13-1.
18-1-99. 13 lordship was lordship. 13-1-99.
He was appointed initially as grade 4 employee under the Guwahati Medical College Hospital on 13-1-1999. But subsequently, he was what? Promoted.
Regularized, irregular.
How can you be regularized? Regularized is what? This is the grade 4 course, MRT.
MRT lordship.
He was appointed as a grade 4.
Yes,
Then what did you become? Were you promoted?
not from the gate, MRT was.
Subsequently, he was regularized as an MRT by the superintendent.
On temporary basis, he was promoted.
What temporary basis? Where is that order of regularization?
Page number 23.
He was appointed as regularized. Yeah, he was regularized with effect from his date of joining by order dated 27/10/2010. Stop. How do you say you are the MRT now? From what document? Which document?
Lordship in page number 31, Lordship.
No.
MR.
In the order dated 27/10/2010, petitioner who was officiating as MRT was regularized in the same post with effect from the date of his joining against the original sanctioned post. Stop. The petitioner has thereafter rendered his services as MRT, and it is his submission that it is his contention that the next higher post is the post of MRO, Medical Record Officer. or medical report officer within bracket MRO. He submits that he has not been considered for promotion to the post of MRO, and accordingly he has filed a representation before the DME. Stop. The DME by letter dated, communication dated 24/10/2019 has forwarded his proposal to the Commissioner and Secretary, Government of Health and Welfare, Health and Family Welfare. Stop. In the same forwarding letter, it is mentioned that the petitioner is an MRO, which is a promotional post. And once promoted, the incumbent needs to undergo training for a period of 1 year in the MRO course. The proposal was sent with a request that necessary approval to depute the petitioner, who is an MRT GMCH, for higher training at Safdarjung Hospital for a period of 1 year. And the vacant MRO post not to be filled up till then. Stop. Now, what is at page 29? This is the promotion order of some other person. Page 29.
Lordship. Lordship, last figure, C. Subhash Das MRT, we supervise the matters related to MRT. Same.
By order dated 31/3/2020, the petitioner was also allowed to supervise the works of the post of MRO GMCH upon superannuation of the incumbent therein. So, however, the petitioner was not promoted to the post of MRO in spite of several representations. Being agreed, he has approached this court praying for regularization in the post of MRO. Stop. The respondent number 4, Superintendent GMCH, has filed an affidavit contending that for promotion to the post of MRO, the person must have the requisite qualification, diploma, and experience as per norms and procedure in the post of MRT. Stop. In a further additional affidavit filed by the Superintendent GMCH, it was held that the qualification, that the petitioner does not have qualification of medical officer, does not have the required training of a medical officer. It can't be medical officer, it is what medical record officer from a recognized institution. Sorry, it does not have the recognized MRT training from a recognized institution. Therefore, his case cannot be considered for promotion. Therefore, he is not a suitable candidate for being promoted to the post of MRO. So, there are learned counsels for the parties have been heard. Pleadings on record have been produced. The case of the petitioner is that he is regularized as an MRT and he seeks his promotion to the next higher post, which is MRO. Stop. As per the communication of the DME, upon being promoted to the post of MRO, incumbent is to be sent for training to the recognized institution for a period of 1 year. Stop. The respondent council has not been able to point out any rules or guidelines to suggest that for regularization or for executing the duties of MRT, training from a recognized institution is necessary, and which the petitioner does not have. Stop. Learned counsel for the respondent has referred to an advertisement which is enclosed to the writ petition. Where is that advertisement?
Page 36.
This is enclosed to what? Your affidavit,
No, it is the petition.
enclosed to the writ petition
Writ petition.
to show that for the post of a medical record technician,
Record of this matter.
for a post of medical record technician, besides being a graduate, training in medical training as medical record technician in government hospital or medical college is necessary. That apart, for the post of medical record officer, the incumbent must be a graduate having medical record officer training from recognized institute. Stop. Upon hearing the counsels for the parties, it is seen that the prescription in the advertisement is for direct recruits, which are sought to be appointed in the same posts. Stop. The case before this court, case of the petitioner before this court, is that the petitioner before this court seeks promotion to the post of MRO. Stop. In this context, the communication of the director, medical education, dated (24/10/2019), addressed to the Commissioner and Secretary Government of Assam, Health and Family Welfare Department, has relevance. Stop. The state communication clearly indicates that the MRO is a promotional post, and once promoted, the incumbent needs to undergo training for a period of 1 year in the MRO course. Stop. However, the affidavit filed by the superintendent reflects that the petitioner is not even MRT trained from a recognized institution. Stop. No reference has been made by the superintendent while in support of the statements, in support of the averments made in the additional affidavit. No reference to any rules, OM, or guidelines, etc. Under the circumstances, this court is of the view that the question of whether the proper training for MRT would be necessary for the petitioner for consideration of his case for promotion to the post of MRO, if the said post of MRO is available for promotion, ought to be examined by the appropriate authority in the department. Stop. While examining the case for promotion, the department will also examine whether MRT training is a condition precedent for considering any MRT like the petition for the promotion to his post of MRO. Stop. The court is of the view that the matter should be decided by the commissioner and what is that, principal secretary, not superintendent. Who is your topmost officer?
Commissioner and secretary.
Commissioner and Secretary, Department of Health and Family Welfare. Who will decide the issue with regard to the claim of the petitioner seeking promotion to the post of MRO from his present post, which is holding in the department, which is MRT. So, the is he a party here,
Yes, responding number one.
namely the respondent number one? The respondent number one will take into consideration all relevant facts and circumstances, including any rules, circular, notification, etc. And thereupon consider the case of the petitioner. Stop. For the purposes of deciding this issue, as it is submitted by the learned counsel to the petitioner, that his representations. You file a fresh representation.
Lordship.
The petitioner, for purposes of deciding, the petitioner will file a fresh representation before the commissioner and secretary within a period of 2 weeks from today. And thereupon, the commissioner will pass necessary orders within a further period of 30 days from the date of receipt of the representation along with the certified copy of this order. The writ petition stands disposed of in terms of the above order as request.
Interim order.
Interim order, if any, shall stand merged in the final order.
Item 24.
Here is the order. Yes.
If the petitioner participated in a selection process for the post of staff nurse. The advertisement located is there at page number 38. Kindly come to page number 38. Page number, the advertisement starts from page number 37. The now lordship will have lordship at page number 38.
Yes.
Close number 7 lorships.
Weightage.
Weightage for service under NHM. Many contractual employees are working under NHM as nurse, paramedics, etc. They may be given weightage of 2 months per year of service completed under NHM, subject to a maximum of 20 months, so that they can be given suitable and justified preference. The petitioner participated in the selection process. And lordship, a written test result was declared. She qualified. She qualified in the written test lordship. Thereafter, lordship may kindly come to the page number 51 lordship. Thereafter, lordship, she participated in the skill test also. There also she got 18 marks lordship. Page number 51 lordship. This is the RTI reply lordship. I have submitted one RTI application. About the marks lordship I have obtained. The reply lordship, page number 51.
51 and 18.
51.
51 and 18. Written test and skill test.
Yes, lordship. 51 and 18 lordship. Experience lordship, no experience certificate serving under NHS. Now lordship, kindly come to page number 40 lordship. 40. This is the application form lordship I have submitted. Name of the post is staff nurse.
Lordship may kindly come to the bottom lordship, 10 years of experience. It is lordship, inclined from the bottom lordship, 10 year of experience. 5 years, 6 months, 4 days. Last experience designation case, disturbed nurse and exam. Now, the documents lordship, which I was supposed to submit, I have submitted all the documents, all were uploaded successfully. But lordship, while publishing the final result lordship, the 10 marks which I am entitled to by virtue of my experience as staff nurse.
What is the cutoff mark for selection?
Lordship, then I don't have time to thank you.
What is your prayer?
Taking my 18 lordship.
Yes.
We award the 10 marks to the petitioner for her service rendered under NHS.
Okay, yes, respondent.
That's why my interest is that I wanted to get the benefit of this experience part mentioned in the advertisement. That is 2 marks for each year, up to a maximum of 20.
2 marks for each year,
Yes, up to a maximum of
20.
21. Page 38.
So 5
there are
years will
seven.
be, 5 years will be 10 marks.
Here, my lord, document that the balance of document that was furnished to us by the petitioner.
What is that? Application.
No, not the petition, but credential. What they will see, my lord.
Identity card, higher secondary. Then PRC,
Not that, my lord.
caste certificate,
Page number 7.
details of NHL, NRHL.
Yes.
NRHL, yes.
Here, my lord, this is the document that was furnished to us. Here it prescribes that, my lord, he joined in the health department, sometimes in 16/3/2015. But, my lord, there is no document to show that, my lord, he was continuing in service on the day when he appeared before this selection board. Means, my lord, the experience certificate, like that of the one annexed in the petition, was not furnished before us.
Is it furnished by NHL?
Yes, sir, it's not. There in
In the petition, here the next one,
Where?
but there also have been placed before the selection board,
Page number
the certificate.
page 35,
35.
35 and 36.
This you have not,
This is not there, madam.
It's
Just
not
showing a date, the appointment date and joining date, but the authorities cannot verify whether she is continuing or not.
you did not show this document?
May I submit documents? Lordship, all the documents were submitted through online process. What were asked for by the online form, Lordship, I would have submitted only those documents. Lordship, may kindly come to page number 41 second. Lordship. Page number 44.
40, there is no last experience designation as staff nurse.
Only Lordship, they have asked for the duration, Lordship, documents, Lordship.
Documents uploaded.
Status.
There is no experience certificate,
Yes,
Mr.
Lordship. Permanent resident, document successfully.
There is no provision to upload experience certificates.
There is no. There
As
is no
per page
provision how I
40.
can upload it.
No, whether in fact, whether at the time when the original documents were verified, that time also she could have furnished it, madam.
During the skill test.
Skill test. Yeah. All the original documents were verified at that time.
Yes,
Lordship, may kindly come.
Because only these are documents that are available with us.
May I submit, Lordship?
Hmm.
Lordship, may kindly come to page number 44. This is the result of the written test. Page number 44,
yes.
written test.
Where is your roll number?
My roll number is at page number 45, last table. that is Lordship, 11/9/2021, Saturday, Establishment Board number 2, Lordship. Third row.
6 column.
1, 2, 3, 4,
6
column, Lordship.
Yes.
Now, Lordship, may kindly come to page number 46.
Hmm.
Important.
Hmm.
All the above candidates are directed to upload scanned copies of their document at the link available at the official website of Directorate of Health Service, Assam.
Hmm.
Lordship, the candidates who have uploaded these documents, Lordship, all the required documents, Lordship, only they were allowed to participate in the skill test. I have uploaded all the documents which were there in the online form available, Lordship. I have uploaded all those documents. Lordship, at no point of time, I was allowed to appear before the board with my original documents.
Now, in the link available, what are the documents to be uploaded?
Lordship, these are the documents to be uploaded. I have uploaded. May I please, Lordship?
Again, a loose scrap of paper. Why don't you bring it on record?
Sorry.
Being sorry doesn't help. Yes.
Lordship, this is on 10/9/2021, Lordship. At the bottom, date is there, Lordship.
This is the same list which you have furnished earlier.
That was Lordship, at the time of submission of the form. application
What
form.
I'm saying is it is on the same format.
Yes, Lordship, same format,
Ah.
even Lordship, all the documents are same, Lordship. I have uploaded once again. And there was no provision to upload the experience certificate.
Yes, Mr. Gowai.
Moreover, Lordship, moreover,
This is not annexed to the repetition, right?
moreover, Lordship, I was working, still I am working under.
That is the whole problem. You don't annex the relevant documents. How will you get instructions? Then
I have been working under NHM, Lordship. It is not a private organization. Lordship.
we know everything, but your experience certificate you could not upload.
There was no provision to upload it, Lordship.
So let him get his instructions.
Yes, yes, Lordship.
Any other documents you want to bring it?
I want to bring it on record by way of.
You bring it by way of one record. Meanwhile, you get the instructions. We are giving you back these documents. Keep it. Heard learned counsels for the parties. The case of the petitioner is that the petitioner's certificate, experience certificate, could not be uploaded in the web portal of the Directorate of Health and Family Welfare in connection with the recruitment of staff nurse to which the petitioner has applied for. Stop. Learned counsel for the petitioner submits that the web portal has a particular format in respect of which the documents required can only be uploaded. He is referred to page annexation 9, Roman 9, page 40, to submit that the documents mentioned, that the categories mentioned, that the documents in respect of the categories mentioned only can be uploaded and which has been successfully uploaded. There is no provision for uploading any document to show the experience certificates. Under such circumstances, the petitioner is agreed that she was not called for this. She was not called for skill test.
Yes, Lordship. I was called for IAPF.
Okay. The grievance of the petitioner is that in spite of appearing for the written test and the skill test, she was not given the,
Mark for experience.
she was not given her appointment, due appointment. Stop. On inquiries made, she was informed that the experience certificate was not enclosed. This information was. How did you come to know that?
RTA.
This was in this the petitioner came to know through the RTA reply dated 1/7/2022, which was furnished in response to the RTI application filed by the petitioner. So. Here, Mr. B. Gogoi, learned counsel for the petitioner, submits that he will obtain instructions as to whether the experience certificate was required to be uploaded in the web portal, and if so, in what manner and in what form. This information, the learned counsel submits will be placed before the court on the next date fixed, least after 2 weeks. And the petitioner is also permitted to file additional affidavit, to bring on record any relevant documents.
Item 25.
Yes, Mr. Rekha.
Petitioners are eligible card.
Here I have got the paragraph for 31st of July. I would like to take on behalf of the final report. Regarding paying the minimum of the pay scale as per the Uganda judgment.
Mr. Rekha. He wants to file an affidavit.
Because all the also they require time. But
Now he says-
there is one matter. That the government is going to pay them enhance wages. But in case they are not enlisted in the list, then they will be deprived from the benefit. They will be also terminated from the service. This I have the is not for the kind of this basis. So that is why.
You are working, yes, your petitioners are working,
Usually, worker.
casual workers.
They are getting wages of 9,000 per month. And government has decided to enhance the rate to 15,900. And
You are working under social welfare.
this is.
Let him file his affidavit.
It's all that we-
Short date, yes.
we can do it.
Mr. B. Gogoi, learned counsel, standing counsel for finance, submits that the instructions have been completed. He would like to bring it on record by way of an affidavit. Mr. C. Dekar, learned counsel for the petitioner, submits that since the issue is with regard to grant of minimum wages and other benefits, the affidavit be directed to be filed in a short date. Mr. D. Bora, learned counsel, also appears for the respondent. Social welfare.
1, 2, and 4.
24.
We are finally affidavit.
And he submits that the affidavit on behalf of
Respondent 3.
respondent 4 has been filed. Let the matter be listed on 21st August, 21st August.
Well, this to be said in the 28. Before that, I will tell you.
25th August.
Item number 27.
Yes.
Next. My father expired on 8/9/2015, died on hard days while he was working as art helper under the civil engineer, Milan Transport Mailer. After his death, immediately I applied before the authority for compensation appointment. And my cases was placed before the DLC Mailer, according to DLC, recommended my case and sent the SLC Mailer. But on a simple ground matter, due to dearth of vacancy, my case was not considered.
Do you have your father's appointment order?
The appointment letter I have my already.
Is it a sanctioned post?
Lordship, document kindly have a look the SLC decision matter, page 19,
Is 19.
page 19, serial number 6 matter.
Simple ground matter. At that time, it was
Decision matter.
Yes.
Serial number 6, the name of the petitioner reflected,
Hmm.
Nitumani Sharma, Director IWT, BA pass, grade 3,
That no vacancy.
my lord, without a vacancy.
That is what he submitted.
My lord, because in our application also, the likelihood of our employee, in fact, we had stated that we had placed his matter before DLC and DLC has considered his case. And SLC is related if the dirt of vacancy, my lord. In fact, this is the SLC 2018, my lord, and petitioner has imposed on a report in the year 2023, my lord.
After the
After
IWT color and they should meet the going pay
Yes,
vacancy.
I know, he will assure you, SLC is related.
Why after so many years? Why have you come after so many years?
21 plus 50.
But why have you come now in 23?
I was regularly visiting IWT.
Also, you can visit for another 4 years. And then come back. Why, what is your ground for coming?
This scheme is for immediate assistance to the state council pilot. So, gate three post is not available. I maybe consider for gate 4 also.
Where is your application? Application,
Application I have not had a small, but IWT has.
you have a copy of the application.
No, my lord, only because lordship and is the petitioner, it is nice BA pass, that's why I think his case was considered for this case. At that time was graduate, my lord.
Hard learned counsels for the parties, this writ petition is filed by the petitioners praying for compassionate appointments. In view of the death of his father, late so and so, who was employed as what is that, heart helper? What is it? Heart helper within quotes, under the office of the Executive Engineer, England Water Transport Department, Water Division. Stop. A learned counsel for the petitioner submits that the petitioner is the only son of the deceased employee. His father died in harness on 8/9/2015. The petitioner, who is a graduate, applied for the same post. When did you apply?
Immediately after.
You have no information. You do not have the application, you do not have the date. Immediately means even 23 is immediately. No, you said you come immediately after rejection. Applied immediately after the expiry of his father. So the same proposal was considered by the DLC, which recommended his appointment to the post, to a grade 3 post. So the matter was thereafter placed before the SLC, and the SLC in its meeting held on 21/12/2018 rejected the case of the petitioner for the grade 3 post due to, within quotes, due to dearth of vacancy. Bracket close. Stop. A learned counsel to the petitioner submits that what is the name of the petitioner?
Neetu Mani Sharma.
Submits that the petitioner is available to do any job in any grade, and therefore the department ought to have considered the case of the petitioner against other available vacancies. Yeah. MS so-and-so learned counsel for the department submits that due consideration was given to the petitioner's application, and thereupon, in view of the lack of vacancies available in a grade 3 post, the petitioner's case was rejected. Learned counsel for the parties have been heard. Meetings have been carefully produced. The case being the prayer of the petitioner being consideration for appointment on the compassionate scheme. A reference to the OM dated 1/6/2015 is necessary. So under the same OM, at para 15, the direction of the guidelines specifically prescribes for consideration of vacancies with other departments by the administrative department in the event vacancies are not found to be available in the department in which the department under which the proposal have been submitted or is considered stopped. A perusal of the clause 15 of the state minutes is extracted below. Para. Perusal of the minutes stated so and so by the petitioner, by the SLC, shows that the case of the petitioner has been rejected only on the ground of no vacancy in respect of grade 3 post. So the minutes does not reflect whether the case of the petitioner was considered, was given due consideration in respect of any other vacancies that may be available for accommodation of the petitioner under the compassionate scheme. In that view of the matter, the court is of the view that the guidelines that para 15 of the OM had not been considered by the SLC and given due consideration. So this court is of the considered opinion that the matter will require reconsideration again by the SLC in terms of para 15 and other clauses of the one dated 1/6/2015. So the minutes of the meeting dated 21/12/2018, so far as it relates to the petitioner, is hereby interfered with. The matter is remanded back to the SLC for consideration of the case of the petitioner in terms of the OM dated so and so, more particularly with respect to paragraph 15 of the same OM. The petition accordingly stands closed in disposal of. No order is to post. The entire exercise is to be considered by the state level committee.
Petitioner number 2, my lord.
Who is responding to,
The chairman state level committee for compassionate family.
will be considered by the respondent number 2 within a period of 90 days from the date of receipt of a certificate copy. The petition stands disposed. Who will place it before the,
Your Lordship, I appear for response of 1, 2, and 3.
so who will place it before SLC?
The record is already in the with the SLC, my lord. Therefore, the next SLC,
The
Chairman will
the
say-
petitioner will file necessary applications before the, will furnish a copy, certified copy of this order before the,
respondent
before
number
the
2. Respondent number 2, my lord.
before the director number 4, respondent number 4,
And-
will forward the same to the SLC
Lordship.
for for reconsideration of the cases directed by this court
My lord.
in this order. The petition stands disposed of in terms of the above direction. Yes,
Lordship may kindly add one submission of mine, my lord. This petitioner case is paid by Gillian Justice, my lord, in after 2008.
the learned counsel appearing to the department disputes the contention of the petitioner and submits that the petitioner has approached after almost more than 5 years or almost 5 years after the rejection of the case of the petitioner by the SLC. So then the right that in rejoinder the petitioner, then counsel for the petitioner submits that a copy of the SLC was not furnished to him. Therefore, he was not aware of the decision of the SLC. And it is only, how did you obtain this copy?
I don't.
He, however, managed to collect it upon repeated
Director.
request from the office of the director, IWD. Yes,
My lord.
Lordship, I appear for respondent was 1, 2, and 3.
Respondents will soon
I'm doing
appears.
for my lord.
Respondents. Yes, it is.
Keep your blessing.
March of the.
Item number 28.
Yes. Malad, this is a very peculiar selection held by the Ames. One of the posts were advertised. I am interested in the post of microbiology, associate professor and assistant professor. Now, I appeared for associate professor, the private respondents also appeared for associate professor. RTI reply says there was only one interview.
There was only,
One interview. By this time, they had maintained one or two separate sheets, but there was only one interview. Now, in terms of that interview, my lord, for the post of, if my lord can have that RTI reply at page 79.
yes,
My lord would have the query at serial number 5. Information sought. Whether the interview for the post of associate professor and assistant professor were conducted separately, or there was one and same interview for both posts. The reply is one and same.
you were applied for?
My lord, I had applied for associate professor in microbiology and assistant professor,
Oh, both.
both. Now, my lord would see page 96 is the result sheet. Then in my lord, the details are given.
Yes,
Now, my lord, associate professor A, recommendation of standing, associate professor. Serial number 1, Deputy Collector, he was appointed. 2, Vikramjit Doctor, that is the petition, my lord, waitlisted 1. Now, when it comes for assistant professor, the first post requires 6 years of experience, second post requires 3 years of experience. Now, my lord would see, one Kaushalya and one Rajeshwari has been selected. Now, my lord would see the next page, the marking. Now, Vikramjit Datta, for associate professor, he was given 67.3. But for associate professor, assistant professor, he was given 63.2. My lord, the parameters are the same, the questions are the same. How can there be my lord, two outcomes of the same result, same exercise? And my lord would see the others, they got 66.8 and 62.0 in associate professor, whereas for my lord, assistant professor, 68.2 and 67. So they were appointed.
yes,
There was only one selection. That's the RTI reply. Now they can't go beyond that. If that be so, my lord, one selection, yes, you have maintained two mark sheets. Let's say, my lord, they have maintained 2 sheets. But you are satisfied with one question, the answer, and for one post you give 67.
associate is a higher.
Higher post, my lord.
You are now working as what?
I am not here, I am in Delhi. In some
In-
of the
in what-
Southern also.
In what capacity?
I am working there as an associate professor. Because he wants to come back here, that's why, my lord.
So you are an associate professor there.
He was.
So you're
willing to come
you're
back.
more familiar with the queries relating to associate professor, so you get higher marks.
It's not the question. of
Assistant professor, you
No,
may
there
cover
was only one query. That's the interesting thing.
only one question.
One question, two, how can there be 2 results? Because my lord would see the RTI reply,
They
one
find-
and the same interview.
They find you more competent to be appointed as associate. Yes,
This cannot be done.
yes.
And in other departments where.
It's for the aims.
My friend.
It has gone out of health.
No, I came for the private respondent. I pray the Lordship may take up on that some other day. we require-
So you are for the health.
No, Ames, madam, is not under.
Aims is not under.
Different.
Yes.
Not under the, madam.
Huh?
It will be taken up in some other day for final disposal.
The final, provided you come with your you find your. So what is the ground that you have taken in this matter?
What is the part assessment has been led and also so on the same that that section was held also, but so far in quick succession losses for associate interview was held in quick succession for
It is an interview only.
No, one interview.
These are not OMR or anything like that?
No lordship, but the assessment was separately. And we were looking at that.
They in para 9 says pay 101 letter. When it comes to 101.
And it was, in his knowledge, lordship at that time, he has not objected it. Now when he has not selected,
Para 9 pays 101.
101.
Money pays 101.
No, 101 is the beginning of the order.
The affidavit filed by Popon Chakraborty Manor starts at page 98. Maybe some mistake. Just after the,
It starts at 130, yes.
so Manor will have para 9 there.
Around 9. Yes,
That with regard to the statements made in paragraph 8, the deponent begs to say that the interview for the post of associate professor and assistant professor was conducted together by the standing selection committee on so and so, which was mentioned as one and same to the specific query in the RTA application of so and so. As a matter of fact, separate attendance and separate assessment.
oh, you got somebody else to apply for the RTI. It's not your RTI,
Well,
it's not your RTI.
this RTA.
His name is reflected in para 9.
Fine. Some different theory, but that
He
information
must have been a junior in your hostel.
maybe. Or was he a candidate? This will be have a check.
Anyway, we'll take it up on some other day. This will require some hearing.
Would only have.
Learned councils are in agreement that the matter will require some examination and therefore we take it up on a separate date.
Manoj, can it be on 22nd November?
22nd, we already have more than 10.
Then 24th.
24th.
Let my friend keep the records ready. Because there is an allegation here in other departments wherein such things occasion, the waitlisted candidate was appointed. So let her also get those records before your lordship.
How many posts are there? One post.
The two posts in my lord, assistant professor, associate professor, one post. Associate
Microbiology.
I was microbiology. I was my lord, number
So in microbiology, how many posts?
one associate professor, two assistant. General,
And both are filled up, all three are
all
filled up.
three of them. So I'll have to dislodge one. So my lord, the specific.
Let us have it on 31st.
31st.
Yes, 31st.
And my friend will have those records, at least one out of the manner in which the selection was held for the other post. Because this was a advertisement wherein one of different posts were held.
If you require records, if the records are for your perusal, we can call it.
No,
For our perusal, let us first hear it and then we'll decide if the records are next.
because why I'm saying so,
You keep the records ready.
my lord will only come to page 67.
No, we are not taking up. On
Therein,
papers.
in cardiology, anesthesiology, Malak, one person who was there waitlisted one. The next appointment is for him. In a sense, so because one interview was set. Here, I don't know why two is was taken.
We will take it up on 31st.
Very fine.
Item number 29.
There I have five categories of questions. The measurement of I appear on behalf of. I will take the date.
Mr. PJ Fukan, Learned Council, appealing for the Water University submits that the affidavit has been filed, however, say is not connected to the report. Registry is directed to trace out the affidavit and connect it to the case records. And this is the matter by the next date fix. Mr. D. Bhattacharya appears for the petition. Is on 28th of August. Mr. Sukiya appears for the response.
Item 30.
Yes.
Belongs to the obviously challenges applied for the course of the criminal and high standards. Immediate period of half-age cover. And they have on the ground of cover.
What is our age?
Another 1 year.
Yes, Mr. Sutia.
Letter will be because of, I have received an instruction.
Hmm.
The police selection board there said, if you oversight, her age was, heard, that they thought that her age is overage, that's why rejected. But subsequently came to know that was not done. But after rejection, the petitioner did not approach the chairman of district level committee for review. That's why, they did not review it. So if they direct them to approach it, they will review it.
You show us the instructions.
And so these are good.
What are these?
This is age is 43. This is 642.
As per the government?
Yes, much different.
She belongs to which category?
OBC.
Why two sets of comments in the same matter?
There were two departments, one from personal department, other from other
Okay.
election police.
Now, where do you say that they will reconsider her case?
Here, Lordship, and this is the police department last week.
Police department.
Election police. Last week.
Then where do you say that it will be reconsidered?
Yes, last paragraph number.
They admit that it is by oversight.
I oversaid. So actually, they could not have done it. They have done it, but even our, they are saying, see, as well, approach the for the review of this matter.
All right, heard the learned counsels for the parties, this petition and impact of the petition. Whom had slides. This is under what provision or preferential appointment?
No.
Huh?
It's the advertisement issued by the respondent ballot.
Then why are you referring to preferential appointment?
The defensive matter, they belong to the family of market matter that was under 1998 election. But it can be,
Where is the advertisement?
well, the page connection, given page 46, the and again advertisement.
Where is the advertisement?
Advertisement is an extra matter to
Page number.
page number 10C, page number 32 to 44.
which post are you appearing?
And for attendant, grass cutter, size, mentioned in page 37.
Grass cutter in
Attendant, grass cutter and size. But we find post that preferences for preference part one attendant, preference two, grass cutter, preference three, size. Mentoring says, the next paragraph.
43, 46. The petitioner in response to the advertisement dated 31/12/2021, 2022, issued by the chairman state level police recruitment board, advertising for calling for recruitment to several posts under different categories. One, applied for the post of attendant, grass cutter, SYCE. In that order of preference. Stop. Petitioner belongs to the OBC category. And she submitted her application in response to the same advertisement. Stop. The case of the petitioner, the application was duly accepted. And she was allotted a recruitment ID. Then she appeared. Where? She appeared where?
Annexure attain the page 45.
45.
The petitioner come before the remarks candidate is over.
No, she appeared where in some interview. The petitioner appeared for the interview, which was held for the recruitment process.
Interview the parade ground of 23rd April. Ariana PN Kiloni Ariani.
The petitioner appeared for the physical standard test with a bracket PST or the trade proficiency test. And stop. However, she was presented with a rejection slip. Is it mentioned that you're overaged?
Yes.
Where the remarks was found that the rejection was made on the ground that the petitioner was overaged. Stop. According to the internal counsel for the petitioner, the date of birth of the petitioner was 31/12/1979, and according to that, she was 42 years. When was the selection held?
1/4/2023.
1/4 the selection, the recruitment process. The selection process was held on 1/4/2023, and as on date she was about. What will be her age? It will be about 42 years. So, learned counsel to the petitioner has, where is that notification, age relaxation is there?
Advertisement melon on first to 2000.
Age relaxation, don't you study the brief before you come to court? Permits that in terms of the government notification, for the category of OBC, the next, the maximum age limit, the upper age limit is fixed at 43 years. Stop. And as such, she was wrongly rejected as overaged, and therefore she is approached this court by filing the writ petition. Mr. T.C. Sutia, learned counsel, has appeared for the respondents on the instructions received. Mr. Sutia submits that the department has accepted that there was that the candidature of the petitioner was rejected on the ground of oversights. As in terms of the office memorandum for age relaxation in the category of OBC, the age relaxation is up to 43 years. And 42 years. Right?
Page 34. Relaxation.
34 or
Or a petition member.
34.
Yeah, in advertisement, there is the last time, appointment limit would be relaxed for 5 years in respect of candidates belonging to SC, ST, SPP, and ST. 3 years in respect of candidates belonging to OBC.
As such, however, the petitioner did not approach the authorities in time, bringing to their notice that the rejection of the petitioner was wrongly done and in contravention with the provision, with the conditions of the advertisement. The learned counsels and parties are in heart. The pleadings are carefully produced. The instructions received by Mr. Sutia placed before the court has also been carefully produced. So, perusal of the advertisement reveals that at clause Roman 2, within bracket eligibility criteria, the age prescribed is the age prescription. The relaxation prescribed for OBC is 3 years in respect of the candidates. The government of Assam, by the relevant notification or OM brought out by the Department of Personnel, has relaxed the age of the petitioners, relaxed the age of relaxed the age for candidates in respect of any state government services belonging to the category of OBC and MOBC up to 2 years. This says it is for 3 years,
3 years, 43 years up to.
but your government circular is for 2 years only.
3 years.
The advertisement reflects that the rate relaxation for in respect of candidates belonging to OBC and MOBC is for 3 years. Stop. The petitioner will on the date of the selection procedure was within the date, within the age limit prescribed, read with the relaxations, stop. Under such circumstances, the rejection of the petitioner will have to be held to be in conflict with the provisions of the advertisement, with the advertisements brought out by the Police Recruitment Board. Stop. That apart, Mr. PM, on the basis of the submissions, on the basis of instructions received, submits that the during the scrutiny of the documents, the concerned officers might have rejected our candidature as overage by due to oversight. Stop. In that view of the matter, which authority will reconsider now?
One of the slab and state level police.
In that view of the matter, the chairman, state level
Police recruitment board.
police recruitment board,
Yeah, but
namely the respondent number 4, will now reconsider the claim of the petitioner in respect of her candidature, which she is offered in connection with the advertisement dated so and so. Stop. In that view of the matter, the petition stands closed with the above directions. The petitioner will submit a representation along with the certificate copy of the order. Thereupon, the authorities will consider the case of the petitioner in the light of the circulars issued by the government of Assam and read with the provisions of the conditions in the advertisement, and thereupon pass adequate orders. The representation be submitted within 2 weeks from the date of receipt of a certificate copy of the order. And the concerned authority will thereafter pass adequate orders on the representation within a period of 60 days from the date of receipt of the representation. The petition disposed of in terms of the above.
Recognized.
We are keeping your the communication for the time being. Yes,
In 1934, but my interim query is still the consideration.
I am available. I am not rising.
Right.
You want me to rise? Yes. What?
I'm sorry.
You want me to rise?
Item 32,
Yes.
32, my lord, 3 years balance period service matter. Yesterday, the detective case before this honorable court, and this is this batch of petition. There are so many cases to dispose of, my lord. So they have second time to file separate action for each and every cases. So this matter will come up after 10 days. Silent will fix the matter after 3 weeks.
Whether the case machine will be given order is pass machine. That circumstance machine or hypothetical distribution machine.
We have disposed of many cases.
Yes, dispose of, but
When is the matter coming up?
after 10 days.
Let us wait for 10 days, 10 more days.
17.
17, 8, and
17 days. All right, we'll wait for,
After 17.
we'll give you a date after 17 based on 23rd,
My lord,
23rd. Submitted by learned councils that the connect, that the writ appeal arising out of, writ appeal by the state. Against the judgment and order dated Bhaskar Bhuvan, date is WPC so and so. Is presently pending, presently under consideration by division bench of the court. Accordingly, matter be listed after 10 days. 23rd, list on 23rd.
Lordship, item number lordship 50, it is 50, so the similar madam.
Both matters on 23rd,
58 madam.
23rd.
Yeah, right, madam.
33.
Your lordship, further time is needed to take the instructions.
Further time.
Yes, lordship.
Yes, madam. Mr. D. Bora, learned government advocate, prays for further time to obtain required instructions. I miss so and so learned. N. Decarosa, learned counsel for the petitioner, does not object. List after 3 weeks. 3 weeks.
34.
I'm referring for item number 3 madam. I have received instruction today on that. It's time for filing affidavit.
Matter for
I was serving as Asha worker in a health center. Thereafter, madam, because of my matrimonial dispute, madam, I could not render my service for 1 month. And accordingly, madam, I submitted many applications before the concerned authorities. And finally, madam, Lakshmi kindly have a look at page, madam. And let's have fix, madam. Page 36. madam.
you're challenging what? The order.
The order and the direction.
Where is that order?
There are 2 orders. One is the direction of dated 9/1/2023, page 35. And it's 5. And the subsequent page, whether the next 6, page 36. They could not take a decision. madam. Now the.
No, who says you cannot take a decision? There are 30, page 36.
Page 36.
You have been recommended to be terminated by the committee.
Last paragraph, madam, Lordship, kindly have a look. That, sir, I am unable to terminate her only based on her personal conflicts. Now the, as such, the post is lying vacant. Nobody is working. My salary has been held up.
If you are not terminated, why don't you work?
But I should be, that's what I'm very for my interim period of the. Lordship, if your lordship kindly have a look in the earlier date.
Okay, what instructions have you received?
That's not allowed to work by the Jehumari Gaon Panchayat madam. So
All right, bring it on record. MS so learned counsel for the NHL submits that instructions have been received. Should like to bring it on affidavit. Mr. Jayad Hamad, learned counsel for the petitioner, appears for the petitioner, learned counsel appears for the petitioner. After 2 weeks,
Then may I should be allowed to go to.
this is not the first time.
That's not the first order, my lord. It is that my interim period is still under consideration.
Let them file the affidavit.
Then I should be allowed to join under the myself.
Waits for 2 weeks only.
Right.
MS Sharma appears for the health department. After 2 weeks,
Dates and limit.
date, give a date. You take a date from the court first.
Item 56.
And
Yes. And 56.
that is watching.
Yes.
Lordship, this is petitioning amendment. Lordship, I take matter, the petitioner's appointment was rejected on the ground of balance of service of 3 years. Lordship.
That we fixed on 23rd. Similar matters are coming up 23rd.
Lordship,
List on 23rd. As similar matters are listed. I'm saying that.
57.
None appears passed over. Passed over.
59.
Madam, there is an order of 19/6/2023.
Hmm.
On the next day, text non-departmental committee is also indicate as to whether while making the recommendation, the GLC took into account existing vacancy And if on what basis the SMC subsequently arrived at a conclusion that the vacancy has been
Yes, Mr. Dhor,
1996,
where is the order?
1994.
Where is the
My lord, there is a last order, my lord.
last order?
Last order, my lord. Is,
Rejection already communicated.
that is what, my lord. My lord, I am. We communicate to the council. That is my, it was instruction, my lord. Today I have got the thing rejected by my lord. It was rejected, my lord, so he has to. Second last page, my lord. Now it's a new course of action, let him challenge it, my lord.
I did not receive any return mind.
We get it now.
I'm giving it to him. Second last page, my lord.
Hmm.
Second last page, 28, serial number, my lord. The left hand side,
Laban Das.
Slavan Das, this is the petitioner. My lord, his case was considered and rejected. Does not fall within the 5% category.
Does not fall.
Yes, my lord. So, my lord, if he has anything, my lord, he has to challenge response. Already it has been, my lord, by 14/5/2020. It was rejected. I am handing over my committee, my lord. So this is the cause of action. Unless he challenges that, my lord.
Why don't you consider publishing this in your department website?
My lord. that is the-
Why should petitioners come before the court and direct that we were not informed, we were not been,
my
but
lord.
then you must also ensure that your website does not crash. It has to be in working condition.
My lord, in 1994.
So we dispose it of.
That is
This
my-
order is there.
Madam, in 1923, I have challenged the direction for under what the existing vacancy is there, under what basis DRC is directed.
This order was passed prior to 19/4/2023. On that date, neither council pointed out that the matter was disposed of. Now if you want to assail this order, you assail it.
Yes, my lord.
It's up to you. Or you file whatever you want to do. 19/4 order, this particular order was not under consideration. So this order will either have to be interfered with or recalled or sustained. But for that, it has to be in record.
Your worship, ma'am.
Heard learned counsel for the parties, this writ petition has been filed by the petitioner. Agree by the fact that his application for compassionate appointment has not been decided by the SLC in spite of an earlier order passed by this court. Stop. Learned counsel for the petitioner submits that the DLC recommended your case.
Yes, ma'am.
Recommended his case for against a sanctioned vacant post of grade 4. So however, in spite of representation being filed, the SLC did not consider his application. Stop. On the last date, the learned government advocate was requested to obtain the necessary instructions in the matter. Today, when the matter is called up, Mr. R. Dhor submits that by order dated by minus of meeting held on 14/5/2020, the SLC had already rejected the case of the petitioner on the ground of on the ground that it does not fall under the 5% cadastring. Does not fall under 5% cadastring within courts. Stop. Learned counsel for the petitioner submits that he did not have knowledge of this order as no copy was served upon him. Mr. Dhor has submitted that he will serve a
I
copy.
will take forward.
He has served a copy.
I did not receive.
He will serve a copy on the learned counsel for the petitioner during the course of the day. Copy of the said order presented before the court is kept in the case reports. In view of the decision taken by the SLC in its minutes held on 14/5/2020. No further cause survives in the writ petition and the same is therefore closed. The writ petition is accordingly disposed of as what?
I mentioned that SLC.
You don't need a liberty. Is disposed of in terms of the in view of the fact that the case of the petitioner has already been decided and rejected by the SLC in this meeting. And so the petition disposed of in terms of the no order is to post.
For orders item 35.
Order has been complied with.
Yes, Mr. Council, order complied.
I am not received.
Give him a copy.
Yes, my lord, I will start with me a copy, my lord.
What is the direction? What is the direction?
Direction was to consider the case of the petitioner for appointment in the post of medical record officer. And the order has been passed that he doesn't possess the requisite qualification as indicated in the advertisement. So his candidature has been rejected, my lord.
We disposed of a matter today
Yes,
with a direction to decide this issue. Yes, carry on.
This order has been passed, showing one main ground, the requisite qualification. I had filed the petition and accordingly this honorable court has passed the order. Subsequently, the respondent authority.
You are alleging contempt in response to which order? 1210.
Yes.
1210. So 1210 direction is to consider your case for appointment in terms of the recruitment process. By advertisement dated so and so. So they have considered.
Subsequently, the respondent authority has filed the review petition challenging this order. In which petition, the said essential qualification was the main ground.
Who filed review against what?
My lord, initially when they filed the writ petition, in the writ petition, my lord, the petitioner projected before the honorable court that he along with the private reference number 5 in the writ petition, my lord, they both got tie marks, my lord. And because of the tie marks, my lord, they have not been appointed. So on that projection, my lord, the court has been pleased to dispose of the writ petition to consider the candidature of the writ petitioner. Because the private respondent filed an affidavit in the writ petition saying that he doesn't have any objection if the writ petitioner is appointed. So only on that projection, my lord, this honorable court has been pleased to dispose of the writ petition. To consider his case, and as per the advertisement.
No, what is the review?
That's why I am submitting. In the review, my lord, which
Review filed by whom?
review filed by the department, my lord,
Ah.
state, my lord.
Hmm.
Because, my lord, in the proceeding of the writ petition, my lord, it was not there. In fact, writ petitioner also cited the fact that he does not qualify in terms of the advertisement. Because an advertisement stipulates that, my lord, the applicant has to possess a qualification on medical.
What was the order passed in review?
Which
what-
has been dismissed, my lord.
What is the order? What order?
Review has been dismissed.
Passing, reviewing or allowing or rejecting the review petition?
Rejecting the review petition, my lord.
Rejecting.
Yes. But regarding the contempt petition,
Is it not enclosed here?
Logic is subsequently the review judgment has been passed.
When?
my lord, in the review petition judgment, my lord.
What has dismissed the review petition?
Yes, yes.
Then
Then the review petition, they had taken free the essential qualification. Which is already clarified.
you have filed the contempt petition alleging willful disobedience of this order. This order in the meantime was sought to be reviewed. Perhaps because of the contempt petition. That was dismissed. Now they say that the direction in the petition is for consideration of your case.
In the review petition, their main ground was the essential permission.
The review petition is not relevant, we are dealing with a contempt petition. Of the violation of the order which was passed earlier.
After review, judgment,
Review is dismissed,
dismissed.
then where is the review? It is dismissed, there is no review of this order.
Now the respondent authority. Effectively, that the petitioner have no. essential-
Heard so and so learned counsel for the petitioner, this contempt petition has been filed alleging willful violation and disobedience of the order. Dated 12/10/2020, passed in WBC 1036 of 2020. By the said order, the following directions were issued. Page number 11, last para in view of so and so. Page number 11 will extract. Learned counsel for the petitioner submits that this direction of the learned single judge has not been complied with, and therefore the review petition has been filed. In this matter, notices were issued. The respondents were directed to file their response. Today, when the matter is called up, Mr. P.P. Bora, learned counsel appearing for respondent number
2 and 3 matters.
2 and 3. Submits that the case of the petitioner has been taken up by the authority concerned and considered. Stop the by order dated 28/07/2023. The case of the petitioner was what was the direction here? Dispose of directing principal come chief superintendent. Director medical education. Or 10. The order dated 28/7/2023 was issued by the Director Medical Education. The selection process for the post of MRO under the Directorate of Medical Education, Assam, was cancelled. The MRO, the post of MRO at the FAAMCH Kolkata. Fakhruddin Ali Ahmed Medical College Hospital, Kolkata, has been cancelled, and the selection process of MRO post at FAAMCH is to be re-advertised at the earliest. In that view of the matter, no further order needs to be passed. The contempt petition stands closed, taking on record the statements made by the learned counsel for the respondent, and a copy of his order dated 28/7/2023 has been retained. The contempt petition stands closed. It has been cancelled. You apply fresh and then as and when advertised.
Apply.
Did you get a copy of the order?
No, I have not received it. Maybe
I will
because
serve it.
You serve him a copy right now.
Right now, right now.
Yes. Next.
10:36.
Yes.
Particularly order very matter, 28/11/22 matter. So it is the second step for that, this is the respondent number 5 matter. You must see repeat that step. And I will repeat matter, that is like B matter.
Who is respondent number 6?
It's not high.
Five. Who is respondent five? Huh?
Srimati Himavati Devi.
Who is she?
She has been appointed, madam. Is the Angamari helper, madam. And we had.
As in terms of the order dated 28/11/2022. This court had directed effecting fresh dusty notice on the respondent number five. Stop. Learned counsel appearing with the petitioner submits that attempt was made to have the to effect the dusty service on respondent five, however. The same was not accepted by the respondent number five. Stop. She's working.
Yes, ma'am.
Under which Anganwadi?
So, Bajav Fire. That is at Anganwadi Center number 184.
Under what division or district? Kachar.
Raja Bajar actually is.
Yes, Mr. Bora, who's the supervising officer of this center?
CDPO Raja Bajar and
Hmm.
ES Center. Kasa.
As such, the petitioner will now take steps to the CDPO. CDPO,
Respond number 4.
respondent number four, CDPO Raja Bazar ICDS project. So the CDPO will ensure that the copy of the petition is served on the respondent number five and file affidavit to that effect. So the affidavit and all expenses incurred by the CDPO while serving copies shall be borne by the petitioner.
This is the second time I have filed this certificate.
You may have, but you are questioning an appointment. Or you take a newspaper publication, whichever is convenient.
The witness who went along with the petitioner, madam, he also given a certificate.
Who is that witness?
One Rukhsana Begum.
Doesn't matter, now we are directing again. Let the exercise be completed within 4 weeks from today.
There is a issue, madam.
Interim order, if any passed earlier, will continue.
37.
Review petition.
With the lordship matter, the Indian method, I was directed to take safe that I have already taken safe matters.
It is submitted by Mr. D.P. Bora that fresh steps on the respondents have been taken. However, the office note does not reflect the same. Accordingly, registry to verify and make necessary endorsements is after 2 weeks.
38.
But the DCR payment is already made, but interest payment, we have to, the AG, we also take action, report taken against that. We already did the AG, there's nothing coming up from the AG or not.
Where is the order? Where is the direction?
Nineteen.
Please,
19.
19.
It's
19. Then you pay 9% now. You can't pay.
Yeah, we have already written the AG for payment of this, ACRG.
Interest at what rate?
At 9%.
9%.
Yes, sir.
Very well. Who is supposed to pay the interest?
AG.
Who is for the AG? You are for the AG. What do you say? We are so bold. You are supposed, you have not furnished some documents. Environment and forest.
I'm not aware of that.
Are we supposed to make the department councils aware? You give it to him and show him.
Yes, sir.
Do you have another copy? No. Learned councils appearing for the department submits that the matter is under active consideration for compliance with this order. The learned councils crave leave to this court to furnish necessary instructions in the matter within next 2 weeks. By 2 weeks, Mr. R. Gogoi appears for forest, Mr. R. Ahmed for respondent number 3. Mr. J. Kulita appears for the petitioner list. After 2 weeks, let them go through. Fix a date.
Okay.
39.
Notice has been issued and steps have been taken and respondent has received notice on 7th of 2023. One was again. We have been. We have been for the regulations of the council.
Of the
The council. Because it received notice on 7th of 2023 and it now is not.
it is submitted by learned counsel for the petitioner that the steps on respondent, on the sole respondent has been effected and
Respondent number 3, Lordship.
respondent number 3, responsible respondent. Stop. It is submitted that that in spite of notice being served, no response has come from the sole respondents. In respect of the compliance of the directions contained in the order dated 26/08/2022, passed in WPC 5454 of 2022. So. Is he still holding the same post?
Yes.
Considering the submissions made by the learned counsel to the petitioner, we request the standing council GMC to enter appearance on behalf of the respondent. Registry will mark a copy of this order and to the standing council GMC, Mr. What is his name? Borat. Yes, Borat. So list the matter after 2 weeks. A copy of this order be brought to the notice of the registrar judicial.
Nice.
Item 40.
These project meetings are completely displaced. If they come up, I think.
It is submitted by learned counsel Ms. M. Kechi that meetings in the matter are completed. Matter be listed for admission after 2 weeks. After 2 weeks. Yes.
41.
For the official dated 26/7/2023, the service of the respondent number which is completed.
I am on behalf of the 567. So I want to extend the final.
Mr. T.J. Montrol and council submits that. We say what is your name? Mr. T. Gogoi and council assisting Mr. T.J. Montrol submits that 2 weeks further time be granted to file the necessary affidavits. Mr. Chetri appears for the petitioner. List after 2 weeks for admission.
42.
Non-movement the order dated 28/9/2020. Whether potential and non-payment of tax are benefit.
Notice served.
I will take this one as appeared.
Appeared.
All as per positive.
1, 2, 4, and 7. The service is awaited. You are appearing for? 4. MS so and so learned council. Mr. PJ Soikia, learned council, submits that steps on respondents have been taken. However, no response has been filed to the content petition filed by the petitioners. Stop. MS D Deka, learned council appears for respondent 4. Although
We have not received additional paper.
respondent number 3 is represented by council, none appears for the council. Stop. No representation on behalf of the other respondents also. Let the matter be listed after 1 week. Enabling the learned councils to enter appearance on behalf of the respondents. Pursuant to steps being taken, service being completed.
Yes.
43.
None appears passed over.
44.
Non-compliance of the order on page number 30. Page number 30, sorry, sir. Page number 31.
13,
31, relevant question.
31,
1,
1, 3, 13.
regarding pension ban.
Heard learned counsel for the parties, for the petitioner, this content petition has been filed alleging willful disobedience. Willful and deliberate disobedience of the directions contained in the order dated 4/1/2023, passed in WPC 8109 of 2023. Let notice be issued, returnable 4 weeks. Steps by registered post within 1 week from today. List after 4 weeks.
45.
Non-compliance with the order dated 91/2023, passing absolutely member mother.
Okay, heard so and so, willful disobedience of the order dated 19/1/2023, passed in WPC so and so. Alleging willful disobedience, the content petition has been filed. Issue notice, returnable 4 weeks, steps by registered post on the respondents within 1 week from today, list after 4 weeks.
46.
And this item last for implementation of new impedance response now 4 and 5. As per your lordship's order, my lord, I have communicated the order of your lordship. And now, my lord, the notice will be issued to respond to number 4 and 5. Content on number 4 and 5.
Heard.
I have been for
Anyone for the other respondents?
I have for 1 we received notice and appeared also, my lord. 2 and 3, my lord, already there is one, my
Right,
lord, 4
heard
and 5.
MS B Devi, learned counsel for the applicant petitioner, who has filed his interlocutory application for implement of the incumbents, new incumbents in the content petition number 785 of 2022. Learned counsel submits that which are the incumbents?
My lord, 4 and 5.
Where have you stated?
Engineer and executive engineer, government of irrigation, this is a matter of pension, my lord.
No, who do you want now to be included?
My lord, 4 and 5. In place of 2 and 3.
Kindly come to page 3. Page 2 is the applicant, Bhola Das.
Yes, my lord.
Page 3 are the respondents. Now, whose name do you want to be pleaded? All 4?
No, no, my lord.
Then,
One is, my lord, 2 and 3, my lord. In 4 and 5 I newly pleaded as per IA, my lord.
this is the IA.
Yes, my 4 and 5, my lord. And as per your lordship, I have completed the order of your lordship. And then when I
Submitted that,
affidavit,
the contempt petition also.
I filed additional affidavit to the effect that I have served a copy. A number 148.
Learned counsel for the petitioner submits that the opposite party number 4 and 5 reflected in the IA are required to be pleaded as the respondents in contempt petition number 785 of 2022. Stop. It is submitted that they are presently holding they are the present incumbents of the post of chief engineer and
Executive engineer.
executive engineer. Tetelia, this food division. So in that view of the submission, this IA is allowed, permitting the petitioner to array the respondent 4 and 5 as respondents in contempt petition number so and so as respondents 4 and 5. Stop. The petitioner will file amended course title in contempt petition 785 of 2022 in view of the order passed today in IA number so and so. So the IA accordingly stands disposed of, allowed and disposed of. In the contempt petition, you write, in view of the order passed in IA for 1486, the newly added respondents are to be arrayed as respondents 4 and 5. So amended course title will be filed by the petitioner before the registry, showing the newly added respondents. First, you file amended, let them get properly pleaded. Matter be listed. You file this, the contempt petition will be listed immediately upon filing of the amended course title by the petitioner before the registry.
Otherwise, it's not down, my lord.
Be listed after 1 week. How long will you take?
Well, the 16th of August, my lord.
16 of August, all right, 16th of August, yes. None of his passed over.
I think 48. 47, my lord.
47, I think 47.
47. 47 will just go, none appeal. Yes,
My lord, we will file an IA by way of abandoned person in order to grant us permission to participate in the recruitment process because then again, we have already participated in the election process, my lord. So IA may be vacated.
what is the prayer in your eyes?
My lord, so that we are granted permission to participate in the recruitment process for the post of senior assistant operations. We challenge the previous recruitment process. Earlier, so-
Are you barred? Are they barred?
No, we are not, we just file by way of abandoned person.
What is that abandoned portion? Are you prevented from filing? Are you prevented from appearing?
My lord,
Then,
Perhaps my now is very estoppel part, not challenging this and participating in the other, but there is no.
because we are already challenged the previous one. So by way of abandoned person, we find it. However, we have already participated, so I may be vacated.
vacated means
I might be disposed of.
disposed of. We dismiss it as not press. Since you already participated.
My lord,
Since you have already participated, in the subsequent interview, you have participated. Second selection process, you have-
Second one, but the previous one is under challenge. This is the new one.
previous one is under challenge, now a second one is scheduled. You have participated there in the second process.
We participated in the second.
So what remains there?
Regarding the first one, the understanding has already filed an additional ability.
Very well, others, that will be listed.
There is not text with the.
Our learned counsels for the parties, this IA has been filed by the petitioners. Praying for leave to participate in the selection process for recruitment of senior assistant within bracket operation within bracket NE6 level. Which was to be held, which was scheduled to be held on. Which was initiated by the airport authority. Stop. It is submitted by the learned counsel for the petitioner that the petitioners have in the meantime participated in the sixth selection process. And therefore, this IA which was filed as an abandoned caution for seeking leave to participate. IA was filed as an abandoned caution seeking leave of this court for participating in the sixth selection process. Stop. Mr. Dubey appears for airport authority. You are appearing for? Respondent 10. Who is the respondent 10?
He is one of the selected candidates in earlier round of.
Appears for the private respondent number 10. Stop. Since the petitioners have already participated in the subsequent selection process, that by itself will not prejudice their claims in respect of that will not prejudice the claims raised by the petitioners in WPC 548 of 2023. Stop with the above observation. The I stands disposed of.
I will file our affidavit in opposition yesterday in the meeting.
Mr. Dubey submits that the affidavit in opposition has also been filed. We shall be taken on record. Dispose.
Can I pray for an admission hearing my lord of this vehicle on the next day?
Is there a stay?
Yes, my lord, the interim order passed earlier, might continue.
The writ petition be listed for admission. Give a date, on a date. In September. 11 September. Interim order passed earlier will continue till 11 September.
Item 48.
None appears. Passed over.
49.
Same order, none appears. Passed over.
50.
This paper wrongly listed in order. It is a different.
Motion matter. What was the direction?
Lordship, on the last occasion, the court had basically, Lordship, we are not a party in this matter, but we were called in by the court. to Basically, find out, as to whether, the specific instruction, whether statutory appeals under section, under instruction 162C of the executive instruction under Assam Land and Revenue Regulations, also aggregated by the same authority. And it's a principal secretary. The divisional commissioner has ultimately been abolished. The office of the. So, in check the divisional, thing, authority has been abolished. Divisional name of divisional commissioner. So, check, under which authority does that lie? So, I need some more time also because of the last occasion, our name also was not reflected.
Mr. A. Fukan, learned counsel to the appearing for the GAD. Submits that some further time is necessary to obtain instructions in respect of the appellate authority. To which the petitioner may prefer an appeal in view of the fact that the post of divisional commissioner is no longer in existence. Mr. El Gugoi appears for the petitioner. Mr. Henry appears for. Mr. Henry for
One.
respondent one, Mr. D. Bora for 2 and 3. Respondent 2 and 3. List after 2 weeks.
2 weeks.
Then we It's a date. Yes,
30 August.
30 August.
Leave there. Alright.
It's up to you.
Like a small trade, and name may be reflected, that's why name is not.
Names of the respective councils be reflected.
Name focus not even reflected now. SCGAD.
Be reflected in the post list. Yes,
SCGAD.
yes.
Item number 60.
Hmm. 60. Yes, Mr. Roy,
We have processed the 2 lakh rupees, my lord.
but all right, the petition is not here, so we need not detain you. None appears for the petitioner. While Mr. Roy appears for the respondent. List again after 1 week. Or you have complied with,
No, there is, there are 20 lakhs, 10 lakhs we paid. And 10 lakhs balance, out of which 2 lakhs we have sanctioned now for the disbursement. And then
That-
we have
that municipal matter, ASTC.
2 lakh has been.
So let it be listed after 2 weeks. 2 weeks, get your instruction.
61.
None appears. Passed over.
62.
The order was passed on 17/2/2023. The direction to release the petition of public. Still yet nothing has been done, my lord. Total disregard is the most important.
I have entered appearance on behalf of the respondent. Can you give me 1 week time?
Mr. D. Nath, Learned Council has entered appearance on behalf of the sole respondent. He submits that he requires 2 weeks time to complete his instructions and file responses for advice. Mr. Patwari appears for the petitioner. List after 2 weeks. Okay.
Item 50.
Hearing. Who will appear? Who is there in 50? 50 is done. 51. 51 to be listed. None appears. This passed over.